Uba gang, 1, 2, 3, 1, 2, 3, sound check, 1, 2, 3. 1, 2, 3, sound check, sound check, sound check.
Thanks, Honorable Kupega. I feel properly young, actually. After hearing you calling Honorable Atkinson a young fellow, I mean, oh yeah, no, I've just finished high school. Just finished high school. Honorable members, good morning. And good morning to the Honorable Deputy Minister Hlengwa. And DG, good morning. Thank you very much for joining us. Just on a procedural matter, so we've been asking people to, we've been swearing in our witnesses. The Deputy Minister is bound by the rules of the House. So he does not need to, I've taken advice, we don't need to swear you in. However, DG will have to do that with you. Because we've been doing that with all our witnesses that have appeared. That's part of the procedures. This is not out of apprehension that you will not be truthful to us, but this is for consistency's sake, because that's what we've done. You look very worried, DG.
I'm not worried, Honorable Chair. I actually asked about that, but I was not on the list of the witnesses. I was not in the letter that.
Oh, so you won't be speaking?
No, I would love to.
Okay, no. So let me so let me correct myself. I made an assumption that both you and the DM will be speaking to us today, which is why I have then stated this in your case. But if you wouldn't like to speak to us, then that's a different matter.
I'm more than happy to assist the committee.
Oh, thank you very much. Okay, so what will happen then is that Ms. Ibrahim will administer the necessary an oath or affirmation, depending on your choice. As I said, the Honorable DM is a member of the House, so he's permanently bound by those rules. Over to you, Ms. Ibrahim.
Thank you, Chairperson. Good morning to yourself and everyone else present. DG, just to put your mind at ease, the Act is designed to protect witnesses against occupational detriment and your evidence here being used against you in any way. So it's definitely to your advantage to take the oath. Sir, can I please ask you to state your full name for the record?
I am Matavata Mukonyam.
Thank you. Sir, you are invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. So you'll now be required to either take an oath or to affirm that the evidence you're about to give is truthful. You can choose between the two. Do you have a preference between the oath and the affirmation?
I'll take an oath.
Okay, if I can please ask you to raise your right hand and repeat after me. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
So help me God.
So help me God.
Thank you, DG. You're now duly sworn in. Thank you, Chair.
Thank you very much, Ms. Ibrahim, and thank you very much, DG. Just by way of introduction, the Deputy Minister has delegated authority in relation to the road accident fund by the minister. The minister has sent us a letter to that effect. That, however, does not mean the minister, should the committee members deem so, does not need to appear, and has in fact indicated that following today's hearings, we may simply indicate which day we want to see her on. If that is the decision of the committee, either next week or the week after, she will certainly make herself available. As we all know, the Deputy Minister has been dealing with the Road Accident Fund, and consistently during this process, we have been looking for people with first-hand information rather than just reports about what people were told and that sort of thing. And so the appearance of the Deputy Minister is particularly helpful in that, in that respect. So, Deputy Minister and DG, what we will do is to provide the two of you with an opportunity to just set out your own observations in terms of the issues that we've been raising with during the period of inquiry as they relate to department and ministerial oversight. So that we can then get into the discussion with members. You have sent us a presentation. I just want to be certain that you don't want to project it on the screen, because we're quite happy to arrange that as well. I'm thinking that since it was sent this morning, it may be useful for it to be on the screen in the event that you are going to go through it.
So it might be useful to project.
Yes, I think so, because normally we get the documents a bit earlier and the members have time to go through them. I think if you are going to go through the presentation, it might be helpful for it to be projected on the screen, even if you're not going to go through chapter and verse thereof, if you're comfortable doing that. Can that be arranged? Yeah, just please, Denzel will assist with a laptop.
Chairperson, if maybe through you, because the presentation substantively, and I think maybe it's what the DG was trying to indicate, our uncertainty as to whether he was a witness or not, and that may have led to that late submission, which we would like to apologize for.
No, not a problem.
It substantively covers the legislative framework upon which the department views and handles its interaction with the Road Accident Fund. So we would be very happy to project the presentation, and once I've made one or two remarks, if we then can hand over to the DG, who will take us through that presentation and will elaborate on some of the key salient points upon which the committee may have an interest.
No, thanks very much, Deputy Minister. So we will give the two of you, it's 10:10 now, we'll give the two of you until 10 to 11. I hope that will be sufficient. That's in about 40 minutes time. But certainly at 10 to 11, I will just ask you to wrap up at that point, if that's okay. We will get an opportunity during the conversation to keep flipping between the slides in any case, for any point that you wish to emphasize.
Honorable Chairperson and honorable members, good morning, and to the SCOPA committee. At the outset, we would like to express our appreciation again to the committee for the work which it is doing with what is a very extensive and elaborate inquiry into the affairs of the Road Accident Fund. And as we indicated at the outset of this process, that it would receive our fullest cooperation, and hence we have subjected ourselves to the processes of this inquiry. And I hope, Chairperson, We have done so to your satisfaction in the committee as and when you have requested information. And Chair, secondly, I think as you have correctly pointed out, because there is a particular perception in certain quarters about the role and functions and responsibilities of deputy ministers, to state for the record that upon appointment in July 2024, Minister Creasy and myself, after having traversed the material realities of the department and the entities, met formally in August 2024 to discuss delegations and responsibilities and how we'd structure the work of the ministry within the department. On the 20th of August 2024, the minister duly gave me delegations, which amongst others included the Road Accident Fund. So I believe that context is very important because the entity, the department rather, has got a number of entities, and the endeavor was to have an almost even split around the manner in which we would structure the work of the department. Now, segueing in that fashion, Chair, I think it's important to, at the outset, clarify some of the matters which have been raised by the previous board that we dissolved in 2025. In this context, Chair. One, we met with all the chairs and CEOs with the minister shortly after our appointment in 2024 in a strategic planning session about our expectations as the new ministry. And therefore, it is incorrect to indicate that a mandate was not given in terms of what our expectations were, and subsequently indicated that at the upcoming AGMs of all the entities, we would then have a discussion with the respective boards and entities about what it is that we expected to be done. So that was clearly defined when we met with all the entities, which was its chairs and its CEOs, at that meeting which we had in Egorulen. Secondly, Chair, is to indicate that there was an allegation made of interference to the extent to which the minister is sending letters, and I think a number was given of some 12 to 15 letters, and that the previous ministers did not interfere and that they only wrote one letter. Here's the reality and the context of it, Chair. Entities, just like the department, must produce an annual performance plan. And there are quarterly reports which we receive from what was then called the Public Entity Oversight Unit within the department, which has now been absorbed into what we call the State-Owned Companies Governance Unit, because of the work which had to take place when the Department of Transport inherited SAA, Transnet, TNPA, amongst others, when the Department of Public Enterprises was disestablished. We inherited staff members, we inherited divisions, we inherited work from that department in that split when entities in DPE went to their line function departments. Why that is key is because it is central, therefore, to the work of departmental and ministry oversight around entities. As and when we receive the reports of assessment that has been done by that division in the department, the quarterly reports of APPs and so on, we send correspondence to each entity, every single one in the department, to draw their attention to our observations about their performance. So ordinarily, then they are going to receive correspondence to say you're not performing in area 1, 2, and 3, and you have to sort it out. I've got the batch of correspondence if the committee so wishes to see it, and it can be then the committee to make a determination how that is interference. But what we are not going to allow is a situation where we do not engage with our entities simply because previous styles of ministry is how they were structured. This is how Minister Chris and myself have decided to engage, so that it's transparent and that we do not have a reality of no clarity about what we want. So as I say, that is why that engagement is done, to draw the attention, and it's not just REF, so there shouldn't be a perception that this was a selective approach. To the extent to which the submissions which I'm referring to, before they reach the minister of all our entities, I have sight of them, and where I've got issues, I raise them with minister before she can onward transmit to the entities. And this is with entities within my scope of delegation and outside my scope of delegation, because that is the kind of checks and balance that we have sought to put into the ecosystem. Thirdly, the allegation that the AGM of 2024 was hostile. No, the AGM of 2024 was not hostile. The minutes can be provided of that. But what I did indicate, as I have indicated here before, is that the bone of contention was the continued reckless fishing expedition through the courts to try and sustain an accounting standard which had been deemed to be inappropriate. And we pointed out to the board formally in that AGM that we were not in support of this course of action. And 11 million rands later, I think we have been vindicated, because shortly before that board was disestablished, having met with them, it conceded to the fact that we were right and that they would try to do what was necessary for them to do. But the situation had become wholly untenable, Chairperson. So I raised that matter very, very sharply, and the minutes can be provided to that effect as well. What I was not going to do is mollycoddle the board. It's got a fiduciary responsibility, and we've got an oversight executive responsibility over an entity which runs its affairs on the basis of public funds. And I think that we have wasted a lot of time within the road accident fund ecosystem traversing an area which was a doomsday from day one, when that accounting standard was changed unilaterally without any due process. It has cost the entity and it has cost the public. And we had to engage on that matter. In fact, Chairperson, I dare say that at the conclusion of that meeting, when we had concluded all the agenda items, one of the board members then felt that they had an issue to raise with me, indicating that they did not seem to think that I liked them because of the relationship we had when I was sitting where you were sitting as chairperson of this committee. And I indicated to them that our relationship is not a relationship of likes. It's a professional relationship. And I indicated further that where the board does the right thing, it will have our support. And where we believe the board is not doing the right thing or the entity is not on the right direction, we would draw their attention to that. And that is the nature and construct of the relationship that we had. Here's my confusion then, Chairperson. On one hand, we are accused of interference. On the other hand, we are accused of not being interactive with the board. They need to decide for themselves before they make the kind of wild goose allegations that they make, what they mean by that. What I want to assure you, however, Chairperson, is that our communication with the board has been communication around performance on their basis of their own APP. Now, as I wrap up on the issue of the correspondence, further correspondence which was sent to the Road Accident Fund, and specifically from myself and my office, is on the following matters. One, I drew the attention of the board that the term of office of the CEO was expiring, and I would expect them to begin the process of recruitment, as I've indicated here before, because as per the Act, the board recommends and the minister appoints through the process, through the cabinet process. And minister would have expected that before that happened, we present to her for her to exercise her constitutional duties, that matter be concluded. So that was how they did it and how they would want to do it. We did not prescribe. The only issue was start the process so that come August 2025, we do not find ourselves wanting on this process. That's correspondence number one, which I believe was our responsibility to do as the appointing authority, to say that do not hold us back when the time comes. That's letter one. The second letter was to advise the board and the entity that we had taken a policy decision as per our responsibility to withdraw the Road Accident Fund Amendment Bill and replace it with the Road Accident Benefit Scheme Bill, the RAPS Bill. And we indicated that should the entity want to make submissions to that effect, it was welcome to do so, because policy decisions are the purview of the department and the ministry and not the entity. To my surprise, when I met with the board in May, June 2025, they indicated that they had not been aware of that correspondence. As to why it was not transmitted from the chair of the office of the chair to the board, I don't know, but the position remains. We are at the tail end of concluding now that policy process for the purposes of that bill to now go to cabinet, public comments and onward transmission to Parliament so that the portfolio committee can deal with it. And because we are committed to a legislative reform within the Road Accident Fund to close all the loopholes. The third letter, Chairperson, was a letter to the chair of the board directing, as I've indicated here before, that as you had called them to appear, they must appear. I think I've traversed that area with this committee, that the fact that we were saddled with a situation of executives and the board who wanted to dictate the terms and conditions of how and when they would appear before the committee here was something that was just completely outrageous, and one which I found to have been a lack of understanding of parliamentary process and a dereliction of fiduciary responsibility. So that is the nature of how we have engaged with them. I'm not sure then, in all that I've narrated, what constitutes interference. Above and beyond that, Chair, as part of the engagements which we have had with REF, National Treasury indicated to us that the funding model of the Road Accident Fund in its current form, if you look at the 7th Administration's medium-term development plan, the priorities, which amongst others says tackle the high cost of living. As we continue drawing money from the pump, which is almost R2.17, we are adding to the strain that the public faces. So there would have to be a review of the funding model of the Road Accident Fund. I began a process with Deputy Minister Masondo and consulted, amongst others, with the Road Accident Fund and in meetings with the then CEO of the Road Accident Fund so that they could better present to National Treasury the predicaments that they would have if we were to just pull that kind of funding. It was at my initiative to assist the Road Accident Fund avert a crisis that I went there with the CEO of the then CEO of the Road Accident Fund. And processes have been underway about engagement, and we continue to engage on this matter so that we can bring it to a logical conclusion and understand what other options are available to us. The second one has been that the court roll has been clogged with REF matters, and at my initiative have been engaging with the Department of Justice under the stewardship on their side of Deputy Minister Nell, And we have been engaging on how we can assist the courts, how we can assist REF deal with this matter. We have met on numerous occasions. The point I'm trying to drive home, Chair, is this. The operations of the REF remain the operations of the REF. The fiduciary responsibilities of the board remain the fiduciary responsibilities of the board. And what we need to do as the executive authority is, as and when we realize that there are fault lines, challenges, or shortcomings, is to intervene to assist the entity be able to realize its intended objectives. And that is what we have done. And this is precisely then, Chairperson, why we are here. So I thought I should start off with a particular clarity on the matters which have been raised. I want to indicate to the committee that if members were to go back to the committee reports of the 4th Parliament and the 5th Parliament around the Road Accident Fund, you would realize that we are well within sanity to indicate that REF is in crisis when we found it in July 2024. And ours has been to try and resolve those issues. The board has appeared before you. When we appointed the interim board, we were very clear. Stabilize the entity, restore good governance, ensure controls are in place so that we can return REF back to its core mandate. We remain concerned, Chairperson, and the board is working towards this, about the delays in payments to claimants, about the challenging process which claimants have to endure to be able to have their claims concluded, and the board is working towards that. We are dealing with a backlog, and there has been a very noble and notable attempt, and I'm very happy with the work that the board is doing to deal with that backlog. To the extent to which, Chairperson, at a political level, we have taken the initiative to support the board and actually go out into communities to track and trace claimants who have not been paid. In late November, I was in Jozini in Bambanana with the board, with the entity. And they had been able to track and trace people from within that community. And we brought them in. We set up the entire REF ecosystem so that we could process claims. Why did we do that? Because if we can't reach you by phone, if you cannot travel to Durban, for example, from Jozini, which is very costly, we rather do what SAA's tagline was, taking Africa to the world and bringing the world to Africa. We were taking REF to communities, and people were able to have their claims assessed there. Where is it stuck in the system? And we unlocked that and unblocked, and we made payments on that day. Some of them were at the final stages. The other major challenge is around the issue of claims which come in with lawyers, because we would materially deal with the set of facts about a claim, but the only point of contention is the quantum that had to be paid. And when offers were made, claimants were not being advised by their lawyers that you have an offer, because they would try and push as far as possible. And so that is the intention upon which we have directed that above and beyond the call center, which is there, above and beyond the communication with lawyers, let us go and find the claimants, because most of them are vulnerable South Africans who are unable to actually carry the costs and the time straining and time consuming processes of the road accident fund. And this is a program we intend to keep rolling out as we go to communities to say, you're missing this document and so on and so forth, so that you can conclude claims. Within my office, because on arrival, Minister and I were saddled with emails galore every single day. If it's not an email, it's a WhatsApp, it's a call of South Africans just generally crying out. Legitimately so, we have set up a process within the ministry and designated officials from the department to assist us be able to facilitate queries and questions. And I can tell you, Chair, almost there's what they call submissions, and I've made reference to this. It's a very big bundle of documents on all things that need authorization that come through myself from the DG, and then before they go to Minister. I can assure you, Chair, 99.9% of the time, any batch of submissions that will come across my desk will in one way or other have a ref matter. It because just of the sheer nature of the queries. Now, in a normal ecosystem, Chairperson, that should not be the case. If ref had been functioning optimally, that should not be the case. The fact that we've had to set up these additional measures within the Road Accident Fund work is because of the shortcomings that are there. Lastly, Chair, and then I'll hand over to the DG, also mindful of time, because I'm trying to, for the benefit of the committee, paint a picture of how and when we intervene. The ref is currently under an investigation of the SIU, an investigation whose proclamation we have asked to be expanded so that it can be able to cater and account for the periods up until we dissolve the board, because of the sheer extent of the problems at REF. And that is why and Chair, for the record, we did meet with the then head of the SIU and his team to get a brief as to where things were and to understand better the investigation. And amongst others, they lamented that they were not receiving cooperation from the Road Accident Fund, matter which I raised with the Road Accident Fund board to draw their attention to the need to cooperate with the investigation so that we could close that chapter and institute the corrective action. Chair, we are saddled with a situation where the extent of the problems and lack of cohesion within the board and within REF led us to a decision that on the 15th of July 2025, we dissolved the board in terms of the act, and we appointed an interim board, which I believe has appeared before you, and I would like to believe that you can see the difference. And the whole point, Chairperson, is to turn around an important entity within our ecosystem for it to be able to perform and fulfill its fiduciary responsibilities. I do want to, Chair, clarify one matter here. And that matter is we have received correspondence from the board as per the process that they have undertaken around the appointment of the CEO. And we have written to the board seeking further clarity on the recommendation and the process they have undertaken on that appointment. And so the appointment of the CEO is in process, it's in motion. Luckily, Minister indicated to me, because I've not been in Pretoria this week, that she has received further responses, and we are considering it and doing what is necessary as part of the process. We are engaging in due process in that regard, and we will take this matter to its conclusion via the the cabinet process. Why I raise this, Chairperson, for the record, we did not receive any correspondence from the previous board on any recommendation of any individual or of any process around the work that was being done to appoint a CEO, despite, as earlier mentioned, me writing to the board to draw the attention of the importance of due process so that the minister could exercise her responsibility. And that therefore led to the expiry of the contract between REF and its then CEO in August 2025. So I think that is important, that we are not in receipt of any recommendation, nor are we in receipt of any report. I've heard all sorts of other things. I will not venture into them. Our contractual relationship with the then CEO expired in August 2025. And as I've said here before, without any prejudice, he was well within his rights to apply like anybody else, and the board in its process. Because we don't conduct the interviews, we don't conduct the process. The board does so. They will bring recommendations. We will engage with their process and their recommendation, and we will take it through the cabinet process. Thank you very much, Chair. May I hand over to the DG, and I thank you very much for your attention and look forward to engaging with the committee matters. And the whole point, Chair, is we have an institution which is important that was in crisis. And I think one matter I must raise is that worker intimidation at REF was rife. And one of the things we have asked the board to do is to normalize the working conditions for the workers of REF at every level so that we can journey with them in this important transition from bad to good. Thank you. DG, over to you.
Thanks very much. DG, I will extend your time to 11, not and otherwise you just don't have you don't have enough. Let's say 11:05.
Thank you very much, Honourable Chairperson and honourable members. Chair, I think the Deputy Minister has covered quite a large chunk of what we wanted to say in terms of the department's responsibility. So I'll definitely move with the necessary speed, Chair. The purpose is to brief the committee and assist the committee in terms of conducting this inquiry, Chair. How we do oversight over entities generally, but in particular the Road Accident Fund, Chair, is that apart from the RAF Act, we also are mandated by Section 63 of the PFMA, which makes the Minister the executive authority of a public entity. And that is why we then have to concern ourselves on a number of issues, performance, financial prudence, and the like. Chair, the Minister is the executive authority. We relate to entities, and then RAF in particular, by way of approving their strategic plan at every 5 years, annual performance plan every year, but we also at the beginning of every year enter into a performance agreement. Others are shareholders compact and the like. With RAF and 102 is the performance agreement. And then we translate this commitment, like I said, into performance agreement, and then monitor delivery. They provide quarterly reports on financial and non-financial performance, and we provide through the minister feedback on the analysis of their performance. For example, we do get worried when the performance is not picking up. And the minister, of course, has got a responsibility to then appoint the board. Chair, this is the legislative enabling legislation that formed RAF, Section 2 thereof. I wouldn't, for trying to sound pedantic, go into the details. But then, Chair, the power to appoint the board is in Section 10 of the RAF Act. The process, unlike most entities, when people therefore have been nominated and a shortlist made, and the minister considered the nomination committee's recommendations, we go to cabinet, and those lists needs to be gazetted for people to then comment on the list of the proposed people that we need to look at if really there are issues around the appointment of a particular person. Chair, filling of vacancies, again, talks to that issue of appointment of the board. Now, the board may be dismissed or dissolved for a number of reasons. And that power is with the minister in terms of Section 10.3. Chair, read together with 71 of the Companies Act, Chair. Now, when the board is to be dissolved, if there are compelling reasons and grounds to take such a move, they are then given an opportunity in terms of the Audi rule to indicate why they should not be dismissed. And when, after making representations and after considering the representations, it's still the minister's prerogative to then continue with the dismissal or probably consider positively their inputs, Chair. Now, at RAF, that was exactly what happened in terms of the former board. But, Chair, you would realize, and they are in the later slides, and I just want to deal with them now, those issues. We've been having some challenges with the board, as the Honorable Deputy Minister just indicated. But I think what really broke the camel's back is the complaints that they were not cooperating or even hindering the SIU investigation. So that's the first one. There were issues around the handling of the CEO suspension, special leave, forced leave, and so on, and the like. And the main one, Chair, was I think their refusal, or the attempted refusal not to come before Parliament, both SCOPA and the Portfolio Committee on Transport. And that was when I think the minister then decided to, the minister decided to say the board is also not helping. Maybe we should ask them why they should not go. So I just wanted to give that the issues around what happened to the previous board. And then there was a need to deal with the lacuna, which of course was not necessarily long. Firstly, in terms of fulfillment or compliance with the PFMA, 49.1 gives the board, says the board is the accounting authority, the board of control. And then 49.2 says if there is no board, the CEO then becomes the accounting authority. So it's automatic, it's not necessarily something that needs a process. But then you had a situation where there was an acting CEO and a suspended CEO at RAF. And then there is 49.3 that says the National Treasury may appoint a functionary of the entity or entities within government as the accounting authority. We opted for 49.3 and then we wrote to Treasury. But I think as we were discussing with the Treasury, there were a number of issues that we needed to navigate, more especially the issue of the CEO versus acting CEO. And that was when a decision was taken to, as a matter of agency, to plug the hole, fill in the gap by appointing an interim board, which is the board that Chair you met yesterday. I will skip a few slides because it still talks about the appointment of the board. And in the board, there should be a representative of the department. And then the act is clear, it says the Director General or a senior official. The process that we embarked upon, we had a member, Mr. Ramansi, who was head of our strategic planning unit, who then left because he got appointed at the South African Reserve Bank. We looked internally, obviously, because of the challenges at RAF. We needed to be very careful in terms of who do we then nominate to go and serve at the RAF board. It was not possible for the acting Director General to go there because of the complexity of the other matters and the fact that the department has just adopted or been given the responsibility to deal with, to manage SAA and Transnet. So the issues were just compounding. And we then had an official from the Rose branch who is Mr. Kani Mashimje. She was here yesterday to be the DOT rep at the Road Accident Fund. Chair, because we use the two acts, the RAF Act as an enabling legislation and also the Companies Act. The RAF Act does not prescribe the issue around the AGM, but we then use other pieces of legislation to make sure that there is this interaction and interface with the board through the AGMs. And that's why we do, like we do with all other entities, request to meet them so they can account to the minister at the AGM's chair. The one matter I forgot was what the deputy minister spoke about, which was also a bit worrying and has been going on for some time, the fights with the Auditor General. That led to what happened to the previous board. Chair, there is an element around board evaluations, but you would know that some of these are self-evaluations, in that the board would indicate what they've been doing individually and collectively, and then submit those reports for analysis. What we want to do going forward, Chair, we want to have an independent and external evaluation of the board. Chair, the Deputy Minister spoke about the issues around the appointment of the CEO, the acting CEO, and the interim CEO. I would certainly try to I'll move away from this. Chair, this committee would definitely do a better job in articulating provisions of the VFMA, especially Section 39 and 86. So I'll definitely also skip this. 39 is the responsibilities of the accounting authority, and 86 is those issues around financial misconduct and criminal charges and so on. Performance agreement between the minister and the board. Chair, I indicated that so far as RAF is concerned, we do have a performance agreement on the deliverables that they need to do and the clarifications of role. Chair, the one that is current is the one that was signed on the 27th of March. That's the last bullet. last year, talking to 25-26 financial year. Chairperson, going forward, as I'm beginning to wrap up, going forward, Chairperson, we because of the lessons learned around RAF in particular, but also one or two other entities, these are the things that we would want to implement as a department, of course, led by the minister. Linking the performance bonuses to organizational performance. The difficulty with the entities, like in other companies, the shareholder has a very limited role in some of the issues, so that the shareholder is not seen as interfering on the fiduciary responsibility. Some of this matter belongs to the board, but we can request reporting on them. Like, for example, the issue of paying bonuses. If we agree a mechanism on how they need to be regulated, then the board will have to deal with it the way we would have agreed in the performance agreement and or shareholders compact. And then the intervention measures for poor performance, Chairperson, we would really want to put a threshold in terms of meeting the targets and what would necessarily constitute a poor performance on the IPP targets. Anything less than 60 would be viewed as such. Chair, and then I would skip the issue around travel, but we are very interested in the audit outcomes and the control environment within the entities. And this we will want to tighten and deal with it in that they need to report regularly on the post-audit action plan that they would have prepared. Chair, this matter of the accounting policy, we have now also, as a department, been requested by the AG to ensure that the road accident fund reverts to the approved accounting standard and not continue with what they are doing. I think yesterday they did indicate that they are reverting back. It is a matter which we have an obligation, we have an interest in, but we also have an obligation as it is part of the commitments that the minister has agreed to with the Auditor General. And the other issues are decent labor, other labor-related matters. But of importance, Chair, apart from us receiving back to office reports from the shareholders rep, there will be a need that the board resolution register be submitted regularly after meetings, and we look at really having a site of what are the key issues that the entities, key decisions that the entities are taking. Chair, we are also required, or the entities are required by Section 54(2) to get approval of the executive authority if they are to embark on either major restructuring or major acquisitions of assets or disposal of non-core assets. So there is that we can use those kind of provisions. And then what we also want to add onto the basket is what we then call accountability framework. It is one thing to have to clarify roles and share responsibilities, but we need to then have to augment this with accountability so that people take accountability for their actions. Chair, and then I think the other issues going forward is just to re-emphasize the issues of performance reporting and the consequences for non-compliance. We certainly do financial oversight, and like the deputy minister has indicated, and I think the board also did indicate yesterday that the financial model for the road accident fund is not sustainable. The ratios are not showing us a good picture, and I think this is for government beyond the department that needs to look at it, Chair. Annually, you need to spend 20 billion, and then you have around 4.55 billion. The gap just increases, and your contingent liabilities grow. They will never be manageable. The most important, other important thing, Chair, is that we want to change the legislation. There are a number of issues that are giving us challenges. The payments of general damages, foreign claims, money going to mainly lawyers and not to the claimants. And then the issue around revenue risk. And if this was a public company, it would have been closed long time ago by auditors, because technically it is bankrupt. I think the fact that there is a guarantee in the form of a fuel levy is what it is saving it. But the majority of this are in the RAPS bill, which we are reintroducing into the approval processes. Chair, you will engage with it when it comes to Parliament. But we really need urgent reforms at the RAF. If this piece of legislation will take long, really we'll have to find other mechanisms of intervening in the interim. But we want to believe RAP's bill has got very good proposals. Our biggest enemies will always be lawyers, because there is an issue around the usage of legal practitioners. We are not saying people should not do that. In fact, it's a very good thing, but the manner in which the current system is being applied or taken advantage of needs to be looked at and be tightened, Chairperson. I think I've spoken about the issues that we would want to incorporate into the new legislation. And we can only update the committee to say we have dusted it off. It is getting back into the sausage mill. And then we have already consulted with in-government, with the departments that we believe are our key stakeholders. And given time, we are going to take it out to the public and the NEDLEC processes, and then back to cabinet, and then have it come to Parliament. Chair, that was my last slide. Thank you very much.
Thank you very much. I just have two questions for clarity. So, and this is for my education, because I have come across this at in the case of the PIC as well. So the shareholder represented. What are the shareholder representatives' reporting or accounting obligations to the department in terms of what's happening in the organization in which, on whose board they sit? And I'm asking this because, I've seen this at the PIC where, there was a shareholder representative at, what's that chicken place? at daybreak. And things went really south, and to the point where the board had to be dissolved. And I thought, well, if there's a shareholder representative there, I mean, Treasurer should have known way earlier that things were going south. That's one example. And then, of course, you have the Road Accident Fund as being another. And I'm sure there are many others. So I just do want, in general terms, so it's not just about the Road Accident Fund, in your understanding, what those obligations are. So that's my first question for clarity. The second question has to do with your legal advice in terms of existing obligations to claimants in the event that legislation is changed, right? In other words, we get the RAPS Act in place. What happens to existing claimants? Does that obligation vanish into thin air, or is it an obligation that continues fiscally to need to be provided for, and that in effect then you'd be running two schemes? And if that is so, the fiscal earthquake never goes away. It goes away over time, but the financial weight on the system actually doesn't go away. So I just want to know what what your advice is. Can the RAPS Act be retrospectively applied to change the nature of the legal obligation on existing claimants not yet paid out? Thanks. It's just those two, and then I'll start with Honorable Mende and we go that way. If you can just clarify me on those two things.
Thank you very much, Honorable Chairperson. The shareholders' representative, and probably that is the limitation and the weakness in legislation, but also across, even in King 4, they are just the eyes and ears of the shareholder. They do not carry a mandate to go and direct the board. Now, worse is even that they don't vote. They don't have voting powers, unfortunately. And that is why I think the other day there was an issue around the department took long to appoint a shareholders rep, and then we could not get a message from the minister. No, that is not the message. The message is to be a board member, and a very lame one, unfortunately, with no voting powers. But they have an obligation to go and report to the shareholder in terms of what had happened. It is not necessarily that the shareholder needs to act based on that, because they need to wait for, the shareholder need to wait for proper board resolutions to be able to act. And I think it needs to be looked at across. But you also don't want a shareholder that would then dominate the board meeting, and I think that was the striking of the balance around that issue. We tell them to come and report to us, but we don't make it really quite clear and obvious that come and gossip. Chair. So that is the dilemma in terms of the people we call shareholders representative. The powers are not really as what we would want them to be. Ordinarily, and even in terms of the Companies Act, you invest, you form a company, you give it to the directors to run, and then you meet them at particular points, whether you have scheduled meetings or AGMs, and they give you reports, they go back to work. And that model is not necessarily working for government entities.
So can I engage you on that? So here's my expectation, so that we don't make the interaction too long. My expectation is that there actually should be a template that the shareholder representative uses to determine whether anything is reportable to the shareholder. So it's not about gossiping, right? Whether anything is reportable to the shareholder, right? And that relates to legislation, that relates to compliance with key legislation, that relates to what may be understood to be systemic problems within the entity, that may relate to a pattern that demonstrates that the approved APPs will not be met within the period. Alternately, the APPs are not effective, are not appropriate. Right? So you get a finding that says, you know, sure, your APPs are there, but on the key legislative obligations, you're actually not performing well. That says to me, at the point of the finalization of the APPs for approval to the minister, the shareholder representative needs to say, look, I've tried to impress upon the board. I can't vote, right? But I feel that these are the issues that are missing, as an example, right? So I'm saying I just get a sense, and it is a sense, that the shareholder representative is put there with no framework, actually, with no reporting template. And my question when I phrased it was, what are the reporting obligations? Because I understand they should not dictate to the board, but I expect them to report. Could be on a, you know, every 6 months or whatever the case may be, or, you know, that's what I'm looking for. Is something like that there, either government-wide or in the context of the RAF?
Chair, like I say, almost all the legislation will say a company shall be comprised of 6 members and a shareholder rep. Now, that is what legislation would clearly say that. But maybe I rushed into saying gossip. What in our case, what we do is that the shareholder, we met them 2 weeks back, Jam. The shareholders' reps have an obligation to share the agenda with the shareholder, and probably given matching orders. That's the first thing. Secondly, we have a template of what we call back to office reports. That is for every meeting, not even 6 monthly and whatever. Even before the minutes come and whatever. They have an obligation to come and say, these are the things, and this is where I feel there's a mission drift or a deviation from policy. What we have not, and probably the processes like this inquiry might assist going forward, is that they need to delve a little bit into matters of performance. But you would know that, Chair, in the department we have a branch solely for that, performance and oversight of public entities. So over and above the shareholder rep, we have people who analyzes performance and who analyzes financial performance in particular. And that's why earlier on I indicated that the ratios of the RAF are not looking good. So that is how we
No, I think DM wants to add on this issue, and then you'll address the second one. Then I'll leave you alone.
Yeah, no, thank you, Chair. No, the DG is right. Of course, there is limitation to scope of what shareholder representatives can do and cannot do in terms of participation in boards. In the primary instance, the board is the accounting authority, so that is important. And the checks and balance in place are that if you were to have a shareholder representative who was an active participant up to and including voting, then you are a player and a referee. The whole point one, which is that they must attend, they must observe, and they must report back to office, to the shareholder, who in this case is the minister and then the delegated minister's person. So what we have done, Chair, above and beyond the PEO and the SOC gap division in the department, which has been very diligent to overseeing the work of entities and reporting back, is we have taken a decision with Minister to regularize reporting and interaction of the shareholder representatives with ourselves and the entities. So for an example, I can indicate that in December 2025, I received the first report from the new shareholder representative of REF substantively on the issues at the entity, and that was very, very helpful. That's number one. So we are going to create a standard operating procedure on how we interface with the shareholder reps, above and beyond the fact that we have indicated that their reporting should also be to the SOC gap and the PEO within the public entity oversight. Sorry to speak in acronyms. SOC gap is the branch responsible for the SOCs within the department.
So it's not a hole in your socks.
Thank goodness not, Chairperson. And so that's point one. Now, why this process is important, Chair, is that you would also understand that we have identified this as a gap, hence the intervention. I think one must be very upfront with that, and that reporting has been irregular. And we are regularizing it now with this process, and we are pretty certain that following the engagements that we have had with them, it will work. Lastly, DG, it's Schedule 2A companies, right? Schedule 2As don't have shareholder representatives. So we are now, therefore, hence relying on the PEO and the SOC gap to make sure that we've got a holistic ecosystem upon which this reporting will take place. And I can indicate that reports have been coming through. And what we have asked is on the substantive policy matters, because that's the key point, Chair. Our engagement with the entities on the policy matters. The operational matters remain with the board to avoid interference. They must be in a position to be able to engage with us and get a mandate and present it to the board meeting, and it's for the board to decide what it does with it. And we will then take it from there. But what is key is that they must be in a position to know what the shareholder is thinking. So I thought I should just clarify that we are working on a framework, and the DG is absolutely correct that reporting is taking place, but it can still be better, Chair.
Thank you. There was a second point about the RAPs. The RAPs and there's there's like possibly tens, if not, of billions worth of obligation currently. So at the point at which the law becomes effective, what happens to whatever was under the RAF Act? Does it disappear, or does the new act then direct what should happen there too?
DG will start and I'll come in, Chair.
Chair, I must indicate we have not really conversed it with the legal office, but ordinarily, Chair, legislation cannot be apply retrospective unless specifically say so. And the problem and the challenge with this would be you are going to get things that would have been concluded based on the previous legislation, including the usage of forms designed or informed by the previous legislation. So we will have to deal with it, cut off, go forward, and then deal with that book separately, based on the previous claims. Thanks.
Chair, the and DG again here is correct. We're obviously going to, at a particular point, be running two systems because we will have to wind down REF in its current form. And at effective date of the REPS bill, when it's an act, it will then start its processes. But here's the point, Chair, and I think this is why this is key. Amongst others, what we seek to achieve with the REPS bill is a no-fault system, is to curb the benefits, to have a schedule of defined benefits within the Act, to regularize systems, and to, amongst others, also say foreign nationals must have travel insurance when they come into the country, so that we deal with this issue of, so the visa requirements, working with Home Affairs, will have to be also looked at, because that is part, a huge problem within the REF ecosystem. Chair, we're also making a proposal to pay in annuities. Lump sum payments have proven to be problematic. Now, what we also, Chair, have to do is we must not look at the REF ecosystem or REBS ecosystem when it comes in as a silver bullet, because in the first instance, it is a reactive action step to a fatality or a crash, an accident. The major responsibility which we have as a country is to fund traffic law enforcement, to have heightened road safety operations as part of the interventions to prevent the strain and burden which the road accident fund has. So for us is to look at this whole thing as a broader ecosystem, because the cost of accidents is estimated to be anything between 205 billion rands and 260 billion rands to the fiscus every year, when you consider the healthcare, the trauma, the responses, and so on. So we are not just looking at reforms confined to what happens at REF. It's to say, how do we look at an ecosystem whereby the accident in the first place does not arise? That is why you would have heard the proposal for the amendment of the National Transport Act, rather, wherein we are wanting to revert to zero alcohol, because we have got a drinking problem in the country, and it is contributing majorly to accidents on Fridays to Mondays in the evenings. So this, what I'm trying to get at, Chair, is that we are not looking at REF in isolation, and that is the important aspect here. So part of REF's new mandate, or more pronounced, will be road safety. So we will, I think, sensibly, obviously, at some point. And maybe let me lastly say, Chair, the whole point of this heightened work we are doing on backlogs is for the simple point that when we arrive at REPS, we must have cleared the backlog. It is a tall order, but it is one way I think that we are gaining traction on, so that we can also deal with the eventuality that you are raising. But what we don't want to do is prejudice claimants, Chair.
Thanks very much, DM. I must say as a comment, we can canvass it later on, that I think it's important that all of us set our expectations in the right place in respect of how soon or how fast RAPS would provide the solution that it does. Because I am asking this, putting myself in the shoes of the finance minister and the DG of the Treasury, which is, if the law is not retrospective, it doesn't solve the problem for the next 15 years. That's the bottom line. But it's a problem for all of us to to debate and solve, so I'll just leave that on the table. Honourable Mende, we'll start with the 20 minutes now. Thank you.
Thank you very much, Chair. Good morning to our visitors and colleagues. Chair, let me start by saying you have already canvassed the support of my private member bill on the stopping of advertisement of alcohol, because our problems start there. Alcohol is glamorized, hence today we have so many accidents on the road. Secondly, Chair, I'm worried, DG, because that which we think, and I'm gonna quote the DM, is gonna be a silver bullet. It's not going to be. With a state of mind or a frame of mind the department is in, because that retrospective effect is very important. Now, I want to ask you just 3 simple questions on the purpose of the RABS bill. What's the rationality of the RABS bill? Or what's the logical purpose of it? 2, what is the reasonableness or proportionality of the problems you want to resolve with the proposal of the RABS bill? So the reasonableness is that, what do you seek to achieve with it, especially with the burden of the fiscus? So the burden of the fiscus goes 2 ways. Is the burden, as the chair is quoting, on the state to avail funds, but it also a burden and a danger to the next claimant who's going to be in a serious accident, but there's no funds to pay them. That's the reasonableness of the RABS bill. Also, the DM touched on this, and I like the way you are framing it, that there are proposals and means you are putting in place to try and put some kind of policies with Home Affairs to cut the foreign nationals and all of that, because then it's gonna talk to the fair warning. Because retrospectiveness, if I have warned you, we're gonna get married tomorrow, DM, and when we're getting married, mine is mine, yours is yours. I've warned you. But at the time of us getting married, and then there's a law that says even if you are married, then it's in community of property. But I have warned you that my intention is that I keep mine, you keep yours. If the law changes later to something else, we have something in place, therefore we can argue in court. So there is gonna be a fair warning to everyone. And that fair warning is then applicable in argument at court when you want to put this law as a retrospective effect. Now I want to see, what is the department doing in canvassing that retrospectiveness of the law?
Let me, well, I wouldn't have an objection to us getting married, Honorable Member. Chair, the whole point is the RAF in its current form is a fiscal risk. And we need to, not just for the state, but for the claimant. Now, what we need to do, therefore, is create an ecosystem wherein the process is less strenuous and responsive to the claimant. and to the fiscus. And hence I was referring earlier on to the work we are trying to do with National Treasury around revenue generation and exploring other innovative ways to generate revenue for the REF. And the risk, Honourable Mente, of foreign nationals claiming REF is huge, because the actual calculations are done on the basis of foreign currency, and therefore on conversion we pay a huge cost as a country. So those are all issues that we so the REPS bill is a clean-up operation, a mop-up operation of where the leakages are, of where the challenges are. I can also hasten to say that I believe that the courts are wrong in their interpretation around foreign nationals, because I think they have not exercised the clauses of limitation to any rights which prevail in the Constitution. And this is a fundamental problem within the ecosystem. I do not believe that being in the country illegally, and then you get involved in whatever that you get involved in, you have got an automatic constitutional right of full access to rights. Because rights come with responsibilities and obligations. In the first instance, you have to be in the country legally. So those are all the things we need to deal with with REPS. Secondly, is that we would be irresponsible if we do not respond to the public outcry of claimants around how lawyers tend to treat claims. That claims process is problematic, because whilst the claimants have got a right, as the DG says, to use a lawyer, but when things go south within that right, they come back to us. And hence I made the reference earlier on to say offers made are not presented to claimants. And cases go on and on and on and on and on. So that is also one aspect to look at. And thirdly, we do have to deal with the healthcare space in terms of access to healthcare services, in which, because some of the work that REF will have to do is post-care interventions for claimants. So here's how I see the REF, Honourable Member. One, it's a funeral scheme because we pay claim benefits for funerals, right? So it's we administer that. Then there's the death claims. Then there is the injury and medical claims. All of these three things are financial in nature. So they are important, therefore, that at the centrality of what you do with REF, you stabilize the finances of the road accident fund. So it's not just what you pay out, but it's what you generate as well within REF. And hence, then we're looking at options of paying in annuities, because then you ease the burden that you have of these lump sum payments that are there. I'm pretty certain that when the bill comes to Parliament, you will be in a position to interrogate it, and we actually look forward to that process, because you will enrich our whole thinking. And then, of course, as I say, is the no-fault system that we are building into the REPS bill. What I can't, Honourable Member, to be very frank with you, accept is a situation where the REF becomes a money-making scheme for non-injured persons. In that we're losing money to the claims process as opposed to reaching money to the claimant. And that leakage is within how the claims are done, and the extensive, I wouldn't say excessive, but extensive use of lawyers. DG?
Thank you very much, Honourable Diam. I think this issue of retrospectivity is going to be with us. I indicated that, and I'm not necessarily a lawyer. I'm a part maker. The law, because past transactions would definitely affect the rights of people. That is the problem of going back, because and the courts are very strict because of a legal certainty, and people would have been laboring, using whatever was there. But I'm not saying it's not doable, but I think that is the one area that we can spend many more years in terms of litigation. We'll definitely try to deal with it. That's the first part. And then the second part is the RAPS bill. And that is why we need to put our heads together in terms of how we fund the system, whether currently or even in the future, because this does not necessarily mean the RAPS bill will come cheaply. The main issue here is that you can introduce staggered payments. What DM saying, it's an annuity type of payments. And probably we also emphasize rehabilitation. There are people that you'd pay a lump sum upfront, and after 3 days, you wouldn't even tell if the person was ever involved in an accident. So that constant monitoring. But the other issues like no fault system, and then adding other benefits would definitely not make the system cheap, but you can therefore control it in terms of how, and there is certainty in terms of how you plan for it. So I think I needed to just cover those key issues, but there are a number of benefits around the benefit scheme, and the main one is that money will go to the people that are supposed to get the money, more than on the transacting or the processing of the claims. Thank you.
Okay, no, let's make it shorter. The chair says 20 minutes only. You know, all these grounds that you have canvassed, they speak to exactly the key points of the logical purpose of the bill. And that logical purpose also does not impede on anyone's right. If I had, my name is on the system now, I'll be settled in June, and the law is underway, and the law in July says I must be paid in annuity. I don't think there's an impediment of any right, because the settlement is there, but because the next person must also benefit, therefore I'm going to be paid in annuity. So I think the legal minds have to really do their research. They must not sit and say, no, the retrospectiveness of this is going to be a problem in Wara. No, it's not. It's actually going to be a problem for the next person who must benefit. And exactly like you're saying, a person is paid today, tomorrow you can't even see the accident. So those are the grounds that have to be canvassed with the costs should the retrospectiveness of this bill is challenged, because it must benefit everyone. But in its current nature, and if we keep everything as it is today, it's not going to benefit anyone else. And we're not saying we'll not pay, but we're just saying we'll pay you monthly or we'll pay you yearly until we show that you really have to benefit. And we've already told you that this is going to happen. So, DM, I'm going to plead with you that the legal minds have to really sit on this. They must not just brush it and design or draft this law like any other law that's proposed. It has a whole lot of it, because between the rough operating, whatever control you can put in place, it has a problem of the law that exists. If we don't design this law and finish it as soon as possible, there is no control you can put in place which will work perfectly at RAF. Because on the other hand, you're going to have lawyers that consistently take you to court because only the lawyer can claim. Only the lawyer can do this. Only the lawyer can do that. Now, let's come to operations DM. You constantly speak of offers made, but claimants don't know. This goes to payments. Ultimately, the payment is done. The claimant doesn't know the payment. The lawyer knows. Then the claimant doesn't know how much they have been paid. Can't we fix that immediately? Because that's communications problem. And I don't believe there is no such a thing in a law that if I have given you my power of attorney, RAF cannot then tell me there's an offer on my claim. RAF then cannot tell me your claim has been paid. It can't be correct. And this is why many people, like you are saying, every day he knows, every day we get problems. Some I escalate them to him, go DM, please intervene, this and that. And every time these come to us, they 90% of the time, then there's a proper follow-up, then there's a settlement, then everything. But if that person calls, they get told something else, simply because there's a lawyer in between. And I seem to not put my finger into what kind of an environment we are operating in that will treat a claim that comes through the chair of the committee as an inquiry, treated much better than the claim of a claimant who calls in to find the status of their case, yet they will not be told such. So that on operations has to be fixed. It really cannot be going on like that. The second thing, which I also asked with the board, these default judgments. The default judgments that are coming, there seems to be no system to track which court is sitting with how many cases of RAF per day. Sitting in your office, DM, if you were to come here and ask you how many cases are today of RAF in court, none of your staff members can give you that answer. And I seem to not understand why. You know, DM, there is a system in the SAPS. And the SAPS, when the dockets come from court, all of them are captured into the system. That system automatically gives you a tracker that then docket 1 is gonna go in 4 days back to court. Docket 2 will go to court in 3 days. Docket 4 will go next day. So on a daily basis, when you get into the office, you just simply go into the system and it gives you how many dockets will go to court in 2 days' time. And RAF fails to have such a simple system. That seated there, you will know in South Africa how many cases are at court, and monthly you can, or even weekly, every Monday you get into your office, you can see them on the board that there's so many cases going, and ultimately they load the outcomes of each and every case. But that is not a draft. Then there's a default judgment because no one knows that we must send a lawyer. And then tied to that, there are dockets or claim files of RAF that are sitting with a panel of attorneys, which was dismissed more than 5 years ago. Still not back. Those are operational matters. How are we dealing with that, DM?
Menta, so I'm worried about your time. I'll allow you one more after this because, yeah. Okay.
Thank you. Honourable Member, let me start off on this question of retrospective application. I think I indicated in my response earlier on that I envisage a situation where we will have to run 2 parallel operations in this transition, because my outlook is that once the REPS bill becomes an act, it's going to have an effective date. And as crude as this might sound, it would mean that accidents that take place from that date, right? So we still have to navigate even the transitional period and arrangement of REF in its current form and what the scheme will bring. But it's well noted, and we will consider all the legal connotations and subsequent consequences that arrive with that. But in my mind, I envisage a situation that we will have to at some point run until they dovetail and then proceed. So we will look at the issue of the retrospective. Secondly, is look, the law allows for you to lodge a claim yourself or through a lawyer. It's a choice that you have as a claimant. And then your claim will be processed as per how you choose to log it. I can tell you now that if you have chosen to engage a lawyer, we are legally bound to correspond and engage with you through your legal representative. That is the dichotomy of the situation. We do endeavor in correspondence that we receive and that you send, when we respond to claimants, to indicate to them the stage of their claim, and then if a payout has been made, we do indicate that on such a date we paid this amount. Please, therefore, revert to your lawyer. So we empower you with that information. You know, and it comes in many constructs. For example, there is one matter which I'm currently dealing with, where a court directed that the funds be placed in a trust. And we are now, the claimant or the victim, let me put it that way, the victim is indicating that they are unable to access their funds. Now we're trying to navigate a lot of legal conundrum because of how the payout was constructed and where it has landed. So the whole point is, I put this out there as public education. Claimants are empowered to claim directly from REF. They do not have to go through a lawyer, and it is a choice that they have to make. Lastly, obviously you raised the operational issues. We do note them. I think they are the purview of the board and the executives. But I can indicate on the issue around the court issues. That is why I made reference to the process we are driving with Deputy Minister Nell to, amongst others, foster a relationship with the courts to better manage the court role with REF. So we're looking at court management systems. We are looking at mediation as part of the options. At a particular point, we even considered, just given the magnitude of the situation, a structure almost of a special tribunal on REF matters with the status of a high court, to be able to help us adjudicate these matters well outside the clogged court role. So what I'm saying is that we are looking at a vast array of options to deal with this. But at an operational technical level, I think the suggestions you make, we will onward transmit to REF to be able to see how best. But we are looking at it, and the task team is in place, an interdepartmental task team of DOT officials, REF officials, and DOJ. And the next step now is to actually meet with the heads of courts in the respective jurisdiction, because the circumstances are also different. I think I must add that. For example, how Mpumalanga is handling its cases and how Gauteng is handling is very different. And there's elements of efficiency both ways that we can build into a broader structure. So we are actually looking at that, and we are awaiting on the judiciary now to give us a date as to when we can meet and present the various options. And I must say, they have issues they want to raise with us about how we are managing issues as well. And lastly, and I think this is a matter we have put to this committee, has been a matter that was raised and I believe should be looked at objectively, not by us, but I think by the committee, on the phenomenon of acting judges who come from law firms which have got ref matters. That conflict of interest is something that, Chair, I put to you maybe as a committee to also consider, having met with the LPC amongst others. And we will, of course, also raise broadly with the judiciary. Thank you.
Honorable Member, the DM has really eaten into your last question. We're on 25 minutes, so we'll come back to you. We'll come back to you. Honorable Atkinson.
Thank you very much, Chair. Welcome to the Deputy Minister and to the DG. Deputy Minister, I'm always, after spending 3.5 months on this inquiry, I'm always slightly amused by people who claim that there's a choice between people claiming directly and going through lawyers. Do you have any idea how much it costs for a direct claimant to actually put a claim in through RAF?
Well, the numbers have not been aggregated for myself. The whole point I'm trying to make is the options that are available. But the other option, the flip side of the coin, is the cost at which a claimant incurs at the end of the process when a claim is paid. So that is why we're looking at this, because there is pros and cons to both, and ours is to simplify the process. Let me put it this way. The whole point of what we're trying to do is place the claimant at the center of the process to ensure that they receive the benefits that they need to recalibrate their lives.
No, thanks for that. I'm just talking about the immediate situation as it is now, because our chair and the committee have actually aggregated the cost. And for anyone who goes in individually to put in a direct claim, it costs up to 100,000 Rand per person, okay? With all the reports that you need from doctors and from specialists and various other people. So unless you've got 100,000 Rand spare, it's very difficult to come in and do a direct claim, which effectively makes it impossible for most people in South Africa to be able to do a direct claim. In fact, the only way they can do it is through lawyers, because lawyers are the people who've got the pockets that can afford to pay all this money up front. So whatever the system may be in the future, certainly at the moment, while it's very nice to say there's a choice in law, but not really a choice in reality. The reality is that people just don't have money to do individual direct claims with RAF. I don't know if the DG wants to say anything about
before
that.
DG, maybe can I ask, Chair?
Yeah.
Since you've aggregated, was it aggregated how much it costs to go through a lawyer? So that I'm asking for the benefit
Okay.
of our information.
Well, obviously, if you go to a lawyer, the lawyer meets the cost for you. And that then obviously comes off at the end. The reality is that there's actually no choice because people just don't have 100,000 Rand. So it might well cost them more via a lawyer, but it might mean the difference between being able to do a claim or not.
Can be.
Sorry, can I assist? Because what sometimes happens is because we deal with the issues daily for the last 3 months. Sometimes we ask questions for which you or a witness will have a gap. So let me explain where this comes from. This actually relates specifically to the board notice, because the board notice changed the requirements for the registration of a claim to say you must have all your medical, legal, and other reports upfront before you can get a link number or that reference number and you register your claim. So what Honorable Atkinson is referring to is the fact that for a lot of people who don't have the means to pay, if you're not going through an attorney with deep pockets, for a lot of people, you simply don't have the means to pay for those medical legal reports. So I have DM, just for your information, looked at how much they cost. The cheapest is around 8,000 Rand. The more severe your injuries and depending on the number of visits you need, they generally range in the 15s to around 35,000 rand. And one specialist might realize that you actually need a further assessment. Then there are additional problems in that depending on where you're located. So you were talking about Josine. So part of the expense, which lawyers currently take on upfront, is that you might need to travel to Durban, you might need to travel to Joburg and that kind of thing, which means if you're an ordinary person, then it becomes difficult. The last point I want to make is it's not of kind of, there's no, the RAF is still working on the total stats, but one of the patterns that has arisen as a result is that the people who are now able to get their claims onto the system registered and finalize their claims are a higher income band, which means because you can afford to do some of these things. That's where Honorable Atkinson is coming from, and maybe that background would assist in contextualizing the question. Thank you.
No, Chair, it does, and I was quite sensible to that, and hence the question I asked. Because what I'm trying to warn against is that there must not be an assumption that because of the cost that may be incurred by a direct claim, that there's no cost to a lawyer-led claim. Because that's all I'm trying to clear up. I repeat the point. At the centrality of what we're trying to do is ease of process for the claimant, as far and as best as possible, and as less costly as possible. But what the impression we must not make is that there's no cost just because you've claimed through a lawyer. There's massive risk, Chair, for claimants, because you see the cases we are dealing with, some at the end of it, after long waiting, people are not receiving claims. We have presented our issues. I mean, well, REF has presented, I'm advised, to the LPC where these challenges arise. So I just wanted to clarify that, but DG wanted to make a point, and I hope you don't mind our tag teaming, Chair. Thanks.
No, that's entirely fine.
Thank you, DM, and thank you, Honorable Chair. Now, Chair, I think the biggest argument also is also on the other side, because the fact that the lawyer does everything for a claimant, and down the line after a year or so, they still then come on their own through the office of the Minister or DM and say, I didn't get my money, I applied 2 years ago. I want to find out if my lawyer has been paid. That is a clear indication that there are instances where you might not need a lawyer, Chair. That's the first part. The second part is some of these things, the reg, and I'm talking around policy issues that needs to be reformed in the law. The reg forever, and then the lawyers go and settle at the doorstep of courts. Who has been paid all this years? The claimant still suffering, but the lawyers have been, because they're requesting this and that, the very same things that we are all saying they request, they would have been working. Only for the whole thing to be settled. So the system currently does not really work for the claimant, Chairperson. I think that's the emphasis that Deputy Minister is putting forth. And there could be a solution to that. If you go yourself to RAF should have the capacity for people to assist you there and go and demand those reports on your behalf. That is how the system is supposed to work. But again, it's operational issues. These are the things that, if they are not clear in law, as far as the law can go, we will clarify them. But more than that, there are more management issues. Thank you very much, Chair.
The operative word there is should. It should. okay, which more often than not actually doesn't happen, sadly, okay. So it's very nice that that's how it should be, but it's not necessarily actually how it is, okay. The second issue is if you dig a little bit deeper, I think only about 3 or 4% of the claims that actually go through the Road Accident Fund are direct claims, okay? Whereas about 15% of the claims not paid are direct claims, which effectively means if you go and claim directly with the Road Accident Fund, it's almost impossible. It's very seldom that you actually get paid out directly. I mean, those are the numbers that have been given by the Road Accident Fund. So the reality is really, if you do want a claim paid out, sure, go and be a direct claimant, but the numbers are completely against you. So not only is it incredibly expensive, you should be getting help from the people at the Road Accident Fund. You're not. And almost certainly you won't get your claim processed properly. So really only through a lawyer. And I'm not advertising for lawyers. I'm just telling you how it is at the moment. And it's completely invidious. Because as Chair was saying, the NQF levels of claimants have increased dramatically because poor people actually can't afford it unless they go to a lawyer, basically. That is the reality of the situation. That's what we've heard over the last 3.5 months. So I'm actually just giving you information, basically. So I think let's not operate in a world where we think how things should be. Let's look at how they really are at the moment. Okay, then my question around RABs. I think Mr. Brown yesterday, the chair of the interim board, basically said to us that if we were going to follow RABs, we'd need to increase the fuel levy to 20 Rand a litre. He's just said there's not the money there. And I think Chair alluded to it as well by the fact that you're going to have to run 2 systems. So you'll have your data, the introduction of RABs, and you'll have to keep the old Road Accident Fund thing going and the new RABs to come in. So the question is, has anyone spoken to Treasury and asked them if they've got the money to do it?
Well, let me just start off on the previous point you made and indicate that a part of our cleanup operation, and to go back to the backlogs, is precisely because there's a recognition on our part that every claim requires attention with speed and urgency, and hence we are going back as far as we are, and the reach out campaign that we are doing, in public campaign, so that we can go to where the bottlenecks are and meet with the claimants. It's absolutely important to us to do that. So I fully agree with you that where there are bottlenecks, we should unplug them. And you are right when you say the operative word is should. And we are moving towards that, because where there have been lapses and capacity constraints, we've got a duty to, I don't know, borrow the term of the committee, retrospectively go and deal with it. That's why we are engaged in this. And this is the consternation we had. Amongst others, we were settled with a board that was wanting to deal with airy-fairy things up in the sky and so on, fight the AG and so on, whereas the claimant is neglected. That's part one. So definitely recenter the claimant. Well, the interim board is yet to make its submission to us on its reading and assessment of the RABS bill, and I look forward to engaging with their submission. And the bill will go through all the processes, including Treasury. I think we are waiting for a SAYA certificate now so that we can process the bill. So I look forward to hearing, because we had asked the board to look at RABs, so that, because as I said, I wrote to the previous board and indicated to them the changes we were making, and I solicit their input. And we are now doing the same with this current board and the executives to say, look at RABs, and then we will consider it. So we are at a consultative stage on this. So I can't respond to the numbers that Chairperson Brown has given, but I'm sure when he presents, I'll be in a position to scrutinize his submission.
Thanks very much, Minister. And I'm sure a lot of the claimants of the Road Accident Fund will be watching with interest. And I wish you well with that. I really, really do hope that you can make, that you can help, that there's a huge headway made in dealing with the backlogs. I think there are a lot of people sitting there waiting for their claims to be paid. And if what you're doing can result in an improvement, that would be fantastic. And I'm sure a lot of people will be very happy. The second issue I've got about the RABS bill is this thing of no fault, okay? Now, I'll give you two scenarios, and you can tell me what you think about the way people would be able to benefit from it. So under a no-fault scenario, if we take what happened in the last week or 10 days in Vereniging, where that driver of the minibus taxi crashed into a vehicle and killed all those school children, and who's now been held up in court for murder, okay? He'd be able to claim, but all the parents would be able to do is to claim the funeral expenses of their children who died. Is that moral? And then the second thing is if criminals are involved in a cash and transit heist and they crash into the crash and transit vehicle and people in the crash and transit vehicles died, the criminals themselves could actually claim for damages in an accident, ideally in a no-fault scenario. I mean, do you believe that in either of those cases it would be right that people, one, someone who's committed murder, basically, is in a murder case before the court, and the other where criminals might create an accident and would then be able to claim from the road accident fund? Do you think under a no-fault system that would be moral?
Well, I think let us aggregate it in this way. Criminality is criminality, and the law enforcement agencies must be expected and should investigate the matters where there's criminality. The no fault in this case is to expedite and assist claimants be able to access their benefits timely and speedily. But where criminality has taken place and is at play, it must certainly go through the due process. You make the reference to the accident of the children. To be quite frank with you, I have battled to sleep for the past few weeks since that accident because, amongst others, the Road Traffic Management Corporation presents its reports. So that was a major accident. And we dispatched the major crashes unit to these major accidents where 5 or more fatalities have taken place. So on that Monday morning, we asked them to rush to that accident. And by Wednesday, they presented a preliminary report. My heart goes out to the families. Those children died a very horrible death. And I hope that the court processes as they are underway and we're handing over the report to the law enforcement agencies to be able to beef up their investigation and the prosecution so that there can be justice for the families. And that is part of the ecosystem that we're looking at. No fault does not presuppose we're not going to investigate. And I think that the driver should be able to, must rather, face the might of the law. And we must process claims as we should. We're dealing with accidents now in KwaZulu-Natal. We had 2 major accidents in the past a couple of days. We've activated REF to roll out the support and benefits that are due to those families. So I think the two run in tandem, but the whole point is again to place at the center of it the claimant. DG?
No, thank you, DM. I think DM is spot on. No fault does not mean that nobody caused the accident. It just says, regardless of who caused the accident, the victims must be able to be assisted. The people who were, and then the other side will then be investigated. And if somebody has got those other issues like the DM is saying. So it has got very little to do with the fact that maybe even the driver would claim. The families that would have lost lives or have injuries have got recourse, should have recourse to the road accident fund. Before the road accident fund, we used to have what we call the motor vehicle insurance. Now the biggest problem was that the victims had to go and claim from the person who caused the accident or the insurance of that person, because and that we know what happened. And that is why, one, no fault for the victim, it will work perfect. And other related issues are not necessarily affected by this thing.
So the question is, would that driver of that taxi be able to benefit under the no-fault system? The guy that murdered those school children?
Yes.
He'd be able to benefit.
He'll be able to benefit. The only thing is that the other victims will not be burdened to go and claim from him, because he might not even afford, and therefore they will be left without help.
Okay, I think that might be a little bit of a difficult thing to sell to the public. The fact that, well, I understand the value of not having to go and claim off someone else, but I think where someone has been maybe found guilty of murder, or some really serious accident has happened, and the person that caused that accident survives and is then able to claim from the road accident fund, I think you might have a moral dilemma with that, basically.
Chair, I don't know if I may beg your indulgence here. And I understand the point that Honourable Atkinson may be trying to make, but may I request for a particular level of sensitivity around priming our argument around this accident, just knowing what the families have gone through and what one of the parents said, where amongst others they were being masqueraded on social media. We can canvass the merits and demerits of the no-fault system. But our angling has been to try and place at the center the victims and the claimants with speed. Secondly, Chair, is to canvass this view, and I think you tried to make it building on what Honourable Atkinson had said, is that the people who are benefiting or their claims are being processed is your higher brackets. And what we're trying to build, and you see, one person said to me, why don't you just shut down REF? That's not an option, because the poorest of the poor would be hard hit. But we are also alive to the reality that they still remain probably the most disadvantaged, because the pace at which their claims move, because of the laborious things that they have to prove. So what I would want, again, Chair, is when the bill comes to Parliament, and we are quite prepared to engage on this, to canvass the views of members so that we can consolidate on a no-fault system that considers all the material facts that you have made. My only issue is that the matter we are referencing for this example is also before court. Thank you, Chair.
Thanks very much. And then,
Last one.
all right. There was, yeah, okay. Can I just make a comment on this? And then there's just something very quick at the end I need to say, okay. So the issue is there are a number of other things around the RABS bill, and part of it is the issue of paying out annuities, which is going to be administratively incredibly heavy for an organization that's battling just to make single once-off payments. So basically what you're going to be doing is massively increasing the workload of the road accident fund by moving to a situation where you'll be paying out loads of annuities to people throughout the year. So what would be interesting is to know if you believe that they actually have the capacity for that. But before you answer that question, I just want to ask you your view on another thing, and that has got to do with we know about the massive backlog in the courts. We know about the default judgments that have been made. But what about you pushing for a settlement hub to be set up at the Road Accident Fund, where this, I believe, was the way that things worked in the past, about 20 years ago, 25 years ago, where if a matter went to court, it was an exception rather than the rule, okay? So what would happen would be that the claimant would come to the Road Accident Fund, the case would be put, and there would be legally qualified people at the Road Accident Fund to make an offer. And in almost every instance, those offers were accepted, and they very seldom went to court, okay? So what you can do, obviously, is save yourself a lot of money from default judgments, can save yourself legal costs, you can speed up the process, but you just need to make sure that you've got enough legally qualified people at the fund that are capable to be able to make offers to lawyers that are kind of in line with a set menu, I suppose, of things that might happen to people: loss of arm, loss of leg, how bad the injuries are and that sort of thing. So the idea of a settlement hub, Minister, is, I think, kind of the direction that we need to go in this.
Yes. Well, so the capacity issue, amongst others, obviously, what it requires is the staff complement of REF is to be repurposed, skilled, upgraded, capacitated in order to meet the demands of what we want to do. That's part one. But secondly is that we have to build up the technological capabilities of the Road Accident Fund in order for it to be able to be agile and responsive. So the use of AI and all these innovations is important, and we are placing a very high premium. DG will tell you, just across our ecosystem of the transport sector, on information technologies and information systems, to be able to, because we're managing things like permits, right? So it's not, so we really are looking into that, and REF stands to benefit from that, and it's also just a compliance issue. We also obviously have to build, relationships with partners within the space. One thing I love currently around insurance companies is them checking whether you are on your cell phone when an accident occurred and them not paying your claim. I'm very happy about that, because we have to apply particular consequence management as well. But what technological capabilities are they using? So we need to plug in to what they're doing. So that capacity issue definitely as part of the long-term interventions is going to be key. I must also stress, colleagues, we all know as lawmakers here, the processes of a bill take a very long time. So it's not as if RAPS is going to land on our desk tomorrow. We're moving with speed to make sure that it reaches the parliamentary system so that it can be quickly dealt with. And we certainly have to go through public comments and so on. So that, lastly, Chair, yes, arbitration and mediation, very important. It's part of the things that we are working on with the courts around this matter, to actually say the matter need not necessarily have to serve before a judge, but let's have mediation and arbitration as what we do. Because again, I want to stress, Chair, largely the issue is less about the merits and demerits of a claim, but the quantum. It's the money question that we just is at the tail end. We will agree on all the merits of all your issues, of your injuries, of your whatever care you need, right? There's no dispute. Where we are grappling with is how much we have to pay. And so that is why then mediation in this regard, correct. And REF is actually going out to set up these centers to engage with, but I think would obviously have to just heighten the pace. And part of the work we are doing, as I was referencing, Josini as well, is that it's a program that I'd asked the office to do as a test case of how we can lend support, and I found it to be very effective. And we are now setting up a process to be very much active and visible, just to exactly achieve that. So, but I like your phrase, your settlement hub. It's quite a nifty one. Thanks.
Chair, just that last question I want to ask, and it'll take 1 minute, literally, okay. So we effectively at the end of, we may see the minister, but we're effectively at the end of seeing witnesses for this inquiry. The one glaring omission has been the former CEO, which Parliament did send out subpoenas and he chose to ignore them. The question that I want to ask, and I'm asking of our chair and anyone else in the room who might answer, what are we doing about it? It's one of the very first times that Parliament ever issued a subpoena in its own name. Are we just going to allow it to pass by, or is there going to be consequences for the action? I do think if Parliament does nothing about it, it gives a very, very bad indication for the future as to whether people will believe subpoenas or not. But I'd like to know whether anything's been done. Thanks.
I think that's a question for me. And I'm quite happy to answer it. So the matter is with the Office of the Speaker and the Secretary to Parliament. In effect, there are two issues that have to be considered. So you'll recall that our letter asked the Speaker to concur. Second, it asked the Speaker to set out a process that must be undertaken. The concurrence is not so difficult. I don't think it is. The process is important. There are several questions that would need to be resolved. One, who actually goes to lay the charge? Is it a member, and what happens if that member is no longer available, and that kind of thing? That is one example. The second type of question that you may need to answer is, can this committee and the speaker just concur and it goes straight to court, or do you need the House to also opine on it as part of the report, or do you include it in the report? Is it done separately, etc.? The third thing to consider is that the legal team, there's one legal team in Parliament, they've been advising us throughout, and therefore, you know, you have to think carefully about them jumping on the other side and then advising the speaker also on something they've already advised us on. So the speaker and the Secretary to Parliament are seeking external counsel's advice so that they can give us a comprehensive guide in the event that the speaker concurs with us, a comprehensive guide which then also helps us in the process of putting together the report. I have spoken to the Secretary of Parliament as recently as yesterday, actually, so we've spoken about 3 times in the last week and a half on the matter. So it's still very much alive, it's under consideration. And if I were to make an assessment, I don't think there is appetite anywhere for Parliament to be disrespected. I will just leave it there. Thanks. I hope that that helps. Yeah.
Great. Thanks.
All right.
Thanks,
Thank
Chair.
you.
Chair, just there's a, I think DJ on the previous question just wants to add a point.
Thank you, DM. I think I wanted to just add very shortly. Once off versus staggered payments, obviously the back room needs to be well capacitated and the admin is yours. But remember, there are other issues in the RAPS bill that are being proposed, rehabilitation and related issues. Now, what would be the best interest of everyone if we pay you and to your upkeep until the end or until you recover, or we pay you upfront and then you would have robbed others to benefit because in 3 days you are okay and ready to go back to work? That is the first part. The second part is this machine has been working well, and we all know. And you've given the honourable members given the example where RAF used to have qualified people who look into this, and then it is finalize these matters before they even go to court. Now we used lawyers. Now the system was then infiltrated by the unscrupulous people who connived and agreed as early as possible, and then drained the system. But you also have that system of even officials who made double payments, because so it is an all systems maintenance or repair that needs to happen in actual fact, because it happened, and just 4, 6, 7 years ago, things started going south because of, among others, conniving and then doing wrong things to the system. Thank you.
Thanks very much. Honorable Isaac.
Thank you, Chair. Morning, DM, DG. Lots has been ventilated. I think, you know, the issue or the bone of contention, and that's been discussed, and it also somewhat gives me lots of food for thought, DM and DJs, you know, is regarding the RABS bill, and you've obviously ventilated quite a bit on it. The question arises, you know, has enough of research honestly been done on the implications? Because obviously there's the worry that, or the concern of the implication that it would have on taxpayers, terms of the increase of the fuel price because of having to fund a dual system for now or for a protracted period of time, with that would also come, with the volume of claims, would come a huge requirement and need for administration and costs. So I think my colleague alluded to the National Treasury and the discussions with National Treasury and the appetite they would have to sort of support and fund the two systems running parallel until we're able to settle down. I don't know. I think it's just going to be a hugely expensive issue, and the increase in volumes of claims. So I just wanted to raise my concerns with that. And of course, the illegal board notice that, you know, your department is having to live with. We know that, of course, this has had a huge effect. And the question arises is that is the RABS bill going to now resolve that issue? You know, I realize there's a huge push for the RABS bill to be passed through Parliament. It's been on the table for many years. But, you know, I wanted to raise the question of the volume, the research that's gone into it, and what the end result would be. Would it not, at the end of the day, be going from the pot into the frying pan? I'm not sure, you know. So I just wanted to raise that. The rest has been ventilated in detail, so I don't want to be repetitive. Thank you, Chair.
Thank you. Chair, can I ask DG to traverse us on this RABS bill? Because I think maybe, Chair, what would have been useful is that if then the committee had wanted us to do a presentation on the RABS bill. But I think it would be premature to understanding the process and that the bill is coming to Parliament for Parliament to deal with. I think the broad issue we were raising is one of legislative reforms which are necessary for the REF. But if we want to get into that, then Chair, we can come back and brief the committee on REBS. But I would want to believe, Chair, that would be premature, because then we will be getting ahead of the process. But can I ask DG to, because salient issues have been raised, research, increase of fuel levy in the volumes and administration and legal notice, and then I'll just make one or two concluding comments on the response they will give. Thank you.
No, thank you. Before DG comes in, I actually, you know, I was mulling an intervention. So, and this is for all the members. What may occur is that we focus solely on the RABS bill. We have heard over the last 8 to 9 weeks a series of really devastating things about what's happened at the Road Accident Fund, etc., etc. My concern is that they have not been canvassed so far, and we are 2 hours in. So I would just like to ask the members that we are going to look at matters going forward as part of our recommendations. What I fear is that at the end of everybody's opportunity to speak, we will not have gone through some of the things that we've had, which we need to canvass with the ministry. That's the only thing I would say. And therefore, maybe when DG answers, that we just leave the RABS bill to rest for now, if that is okay. That's what I'm anxious about as I sit here. Thank you. I stopped the clock, Mzala, while I was talking.
Thank you very much, Honorable Chair. Honorable Chair, the matters surrounding the RAS bill come a way, way long back. When RAF started experiencing problems, even in the early 2000s, there were a number of commissions. The last was the Sexual Commission by Judge Sexual. That is the one that started talking about no fault and a social benefit scheme and so on. And then those things were then repackaged into the RAPS bill. Now, the RAPS bill started in earnest in the fourth Parliament, went through to the fifth, and then when it was about to be approved, then there were a number of issues at the House. So I wanted to say this because I want to indicate that it went through the entire processes, including discussion and costing by the National Treasurer, including getting the socio-economic impact assessment by DPME, Department of Planning and Monitoring. So it went through those processes, and the issues of affordability were then settled at that time. But we always knew that we are facing a mountain because of the people who were benefiting from the system. There's an interest group that when they decided to oppose the RAPS bill in the inaugural meeting, they pledged on the other side of 100 million to come and fight this thing. And they fought it, and at the time they won. Now, that was the RAPS bill then. The RAPS bill now factors in the recent developments. That's why I think the key phrase should be transforming the legislation or coming with legislative reforms that will suit everybody. So there are elements in the RAPS bill that were contentious need to come back to the table and be discussed. There are elements that were outside of the RAPS bill that needs to come in based on recent developments in the day-to-day administration of the system. There are those issues that coming from RAF itself, which are more operational, and they talk about legislative impediment that will form the RAPS bill. But everything will be on the table, and everything will have to be discussed in a more pragmatic way, not in archaic take off what was there at the time. So I think we just need to wait for that process, and everybody, all South Africans, will have the benefit to discuss this piece of legislation. And the people who need to cost it will come to the table and tell us how much it will cost. Now, I'm not so sure if it will deal with the board notice, because the board notice is the matter of the board to go and consider, even in the current legislation, and sort it out. But there's no legislation that we can bring here if we don't have an indication that it will be affordable for South Africa. If not affordable, something that we'll have to go back to the drawing table. Thank you very much, Chair.
Chief, just because I said I would come, I think here's the point, Chair. The RAPS bill is not a new bill. And it went through all processes. So the research, the Treasury considerations, the NEDLEC process, it went through the portfolio committee. So it went through the portfolio committee, a report, it was scheduled on the ATC, it was put on the order paper of Parliament and came to the floor of the House. It was only at that point, in fact, coming in with the recommendation for approval. But the lobby won the day. And I can tell you now, the lobby is still hard at work. You know, the nice thing about airports is that any Tom, Dick, Harry or Jablani can come up to you and say whatever you want, and you listen and keep it moving. So one smart aleck came to me and said, "Yeah, you that guy from transport, you and your minister are trying to bring the RAPS bill. We fought it before, we'll fight it again. And my only response was that we are equal to the fight. And we are up, and as the DG is saying, we are upgrading and ensuring that the REPS bill is suited for current circumstances, and hence us now awaiting the SAYA certificate so that we can process it to its next stages with a view to bring it to Parliament. Maybe lastly, Chair, I can say this. It's common cause in any legislative process that what we bring as a department may not be ordinarily what comes out of Parliament. So this is an opportunity, as far as I'm concerned, for Parliament to interrogate. What we will do, Chair, even if we maybe not brief the committee, we can bring a presentation on the REPS bill for your consideration in the recommendations you'll choose to make. And lastly, as DG says, the board notice. I've asked the board to look at the board notice, and they must apply their minds and take the correct decision on it, and then we resolve the matter. So it's a matter that I've placed before the agenda of the board to look at. Thank you.
You still have time, so it's up to you. I'm in your hands.
All good, Chairperson. I'm covered, and you can utilize my time for yourself.
Okay. No. No, thank you. No, I will let Honorable. What I'll do is I'll just use the gap between Honorable Kupek and lunch. So let's hand over to Honorable Kupek.
Thank you, Chair, and greetings to the Deputy Minister and the DG, and greetings to the team. Chair, on one of the comments that the Deputy Minister made regarding the direct claims, Minister, I'd like to read to you some of the notes that we took down from the 29th of October 2025, when a certain Ms. Christina Mtetwa and Mr. Brett Phillips were in the House. They said in 2017, RAF executives set goals to substantially increase the portion of claimants dealing directly with the fund. The long-term vision was to achieve an increased growth in the ratio of direct claims versus represented claims by the end of 2020. In the years following the implementation of the strategy, direct claims originations increased from 22,524 in 2015-2016 to over 40,000 in 2018-2019, as reported by their respective RAF annual reports. However, in 2020, in January, they were instructed to stop efforts in assisting direct claims. That was a regional manager, Ms. Dineo Tabete, and the later removal of case management and rehabilitation teams resulted in the collapse of personalized claimant care. No dedicated personnel remained to attend to the functions after the team was dismantled. The RAF's direct claims and associated case management structures were dismantled late 2019, early 2020. In 2020-2021, the annual report acknowledged a change in strategic direction to stop actively originating direct claims. All existing claim files were transferred to a Project Shanyela to wind down direct claims. The RAF management circulated the promotion of cessation of direct claims that on the 1st of September 2020. The COO sent an internal email to this effect. Moreover, the RAF's marketing and communications budget for the public outreach was cut in 2020-2021 from around 12.17 million to 0. All systems and databases used to manage direct claims, including the SharePoint system, were deleted or dismantled. All direct claims policies, standard operating procedures, and guidelines were removed. The RAF reverted to a wholly attorney-driven claim system with no viable alternative path for ordinary claimants. So I'm just shedding light on the issue that we were speaking about when you say that there is a way to claim directly. Now, there's a challenge with, they wind it down at RAF, that's one. Number two, there's a very big challenge in trying to claim directly at the Road Accident Fund. Number one is the RAF 1 form. That's a huge challenge. It's a complex document. It's a document that is only available in English, and it's a properly complex document. Number two, as one of my colleagues said earlier, to claim directly at RAF needs resources, serious resources. So it becomes almost impossible for you to claim if you do not have the money. For instance, if you don't have medical aid to have all of the necessary doctors' reports, you will not be able to claim directly. So that's just a note on that one. I think my first question would be to the DM and the DG. Does the DM and the DG know that there are no systems in place at the Road Accident Fund to monitor court proceedings? Basically, the RAF does not know what is happening in court where they are concerned. No one gives briefs to lawyers when RAF is going to court. Is any of you aware of that?
Thank you very much. I think I would like to start off with the intro that you made, and the whole point that we're trying to make here is that you are saddled with a RAF ecosystem of rogue decisions that were taken in the past, which we are now trying to correct. And we have asked the interim board to scan the ecosystem in its entirety and to regularize towards correctness that which is wrong, to strengthen that which works, in order for RAF to, I repeat once again, place at the center the claimant in whichever way, form or shape that claimant may come to the Road Accident Fund. I would want to believe that those decisions, you would have to engage with the ones that took them, and I think you've cited some names there, including Dineo Tabete and COO. I think you'd have to, it's within the committee's purview to have those people called in and interrogate them and engage with them on why they took the decisions that they took. But for so long as a direct claim is provided for, it must receive correctly the attention of the Road Accident Fund to its logical conclusion. Secondly, yes, I've indicated the REF 1 form. I think there is no hindrance to asking that the form be available in all official languages for ease of process and ease of access for the claimant. But at the same time, as I've said, I've asked the board to look at the REF 1 form and the issues that have been raised so that they are clarified. No systems in place to monitor corporate. Yes, precisely. That's why the intervention from the ministry with DOJ to be able to put in place new systems and build a relationship to ensure that the court processes are better managed. And I think I've indicated today before this committee that we are now awaiting a date from the judiciary in order for us to engage on their issues, because they've got issues as well. And then we will, so we are keenly aware of that, and that's why we are intervening, so that we close all the loopholes. That intervention arises out of that knowledge. DG? But DG just wants to.
No, thank you very much, dear. I think now, honourable member can see the correlation between direct claiming and default judgment. When you increased and provide support for direct claiming, you then had reduced litigation. And when that was, as the member is saying, done with, then you saw an increase So, for obvious reasons, then it is very clear that the direct system was working for the claimant. We definitely will have to implore upon RAF to look at simplifying whether it is the form or whether the methods and provide additional support. RAF's core business is payment of claims and very little else. So the board made an undertaking, I think, even during the inquiry, to augment the legal division, to get people who process claims, more of them. They are claiming to have 400 waiting in the wings. They just need to get them on board, and they need to be skilled in how they process the claims and help the claimant. I've never seen a situation that where you even have a vehicle saying assistance on RAF claims and it's a private vehicle. It's an advert. Maybe we should also introduce into the legislation banning of those that brand their vehicles with the names of RAF. And then we increase. Now there was also a decrease in the marketing and of this direct claim approach. Now, if you increase the fact that people should come on their own, one, they'll be assisted, you reduce the cost of doing business. You are definitely going to get a working system. Pokamoso was, among others, designed to be an integrated system to also track and trace the cases. In the department, we don't deal with litigation on a daily basis, but we have somebody who the first thing that they do in the morning is to look if we are not cited somewhere in a court case. And they alert the department and we're on top of the things. That is on top of what state attorney also does on behalf of department. So RAF, now I said shoot, but one of the best ways is that RAF should have a track and trace system that track their cases in court. But over and above that, an integrated system that traces a claim up to its logical conclusion, even the court interventions in between. That is, I think, like Jim is saying, there are things that they are talking about it. Joburg, the Gauteng South, was it South High Court? The judge president, who's now the deputy judge, chief justice, issued a circular and said that we are no longer going to deal with RAF matters. They should all go to arbitration. And maybe it is something that we should also enshrine in legislation so that it does not become difficult, but it becomes easy to settle things before court. They said it because the court role in that court is clocked in terms of RAF matters until 2031 or something, which is unheard of. So all of us need to make sure that we make the policy clear and unambiguous and simple to interpret, but also the RAF in terms of their processes and SOPs and the way of doing business. They should modernize. They should automate their systems. I was born before technology, but I embrace it because it found me here and it disrupted my life. So I think we need to move to modernize and automate, and half of the work will be solved in that space. May not even need the RAPS bill. Thank you.
Thanks, DM. On that note, yesterday when we were sitting with the board, the interim board, we noted that there are 385 positions in legal that are vacant, and they have not been advertised for. And we also ventilated on that Bokamoto system and I asked them that they must make sure that that system coming in at a cost of R1 billion needs to function, because right now it is not addressing the issue of the major issue at the road accident fund, where everything is paper based. The next question is Can the minister take us through, the deputy minister take us through, how he and the minister went about choosing who sits on the board?
Which board?
The interim board
All
at the Road Accident Fund.
Thank you. So ordinarily, of course, the legislation does not provide for a process in this regard, but it provides for a dissolution of a board, and I think the DG in his presentation tried to traverse this space in terms of the issues. We try to identify individuals whom we believed would assist us respond to the issues on an interim basis as we rolled out the provided for board process and took the names to cabinet. Amongst others, we did consider what is called the long list, which is generally previous applicants to the boards. So we, as clearly indicated, this is an interim board, which is not without precedence, as in when boards have been disestablished or dissolved, or when terms expire, so that we do not create a lacuna in law. And so we looked at to solicit individuals who could respond to our issues, and what we were really trying to do, Chair, is to respond to the gap of an absence of an accounting authority as per the dictates of the PFMA. So it was a headhunting operation of sorts, if I can call it that, whilst we advertised, because the board pillar still had time, the board that we dissolved. So there was no process which we were engaged in to actually advertise for a board. So that is the long and short of that.
Thanks, Dame. What I'm trying to understand is what qualifications or experience were you looking for? Are there certain competencies that you were looking for? Or is it just purely a headhunting? No, I want this one, I like this one, I don't like this one?
No, it was not a matter of like or dislike, it was a matter of competence. And where the ref was at that point and where it is now. So that's why we have got financial people on the board, we have got legal people on the board, and we have got former members of parliament on the board, because at the time we dissolved the board, REF was saddled with two major parliamentary outlooks. One was the pending inquiry, as that committee was busy with the work, and secondly was a reality we had to respond to around the legislative review processes. And so we wanted to tap into the skills and expertise of where REF was when we dissolved the board. So it was not just a willy-nilly soliciting, and we believe that amongst others in getting the caliber of the former CPO, Kenneth Brown, was because we were placing a high premium on the financial management processes and SCM processes which had to prevail within the Road Accident Fund.
Okay, thanks, DM. To the DG, I just want to know, how long has the department had...
Apologies, sorry. I think maybe there's a matter I must correct. My apologies, Honorable, because it's linked to that question, because I think we have a duty to treat people with respect, and if we've got issues with them, afford them the right to respond. Well, for lack of a better phrase, apply the audi alteram partem rule as well. And if there's any issue around the qualifications of the members, then I think it must be legitimately raised. What I found disturbing yesterday is social media posts from members of the committee seeking or alleging that people were not qualified. And with reference, because I know that the point of contention is around the former members of parliament, and I explained the logic, why. And it is not a permanent arrangement, it's just where the board was. I can say that the Honorable Mponjane, he's got a master's, he's qualified, political science. And Honorable Janchi Former has got various qualifications and certifications. I don't think it is fair, Chair, that from the high pedestals of political office and the immunities which we enjoy as members of parliament, it is correct for us to be condescending and denigrating on members of the public who avail themselves to help. And I found what was posted yesterday to be utterly distasteful by Honorable Madlala on his social media pages. And I was going to come to it when he posed his questions, but I think it's only fair I raise it now because it's being raised. I think that if we've got an issue with people, because we appointed them, right? So if you've got an issue with them, raise it with us. To go on in a public disparaging outlook and seek to undermine people's qualifications, I don't think is correct. And because they're not in a position to defend themselves because, well, they're members of the public, it's incorrect.
Good. Oh, thanks, DM. So the only thing I was going to say, I wish this conversation was taking place on Honorable Madlala's time. So what we'll do is then we'll give you, so yeah, so Honorable Kupeka, thanks, DM. I mean, the comment is fine. So what I'll allocate 3 more minutes to you in lieu, because
Thank you, Chair. I think, DM, you must understand that we get it and we understand when you're going to say some of the members were previously members of parliament and they have certain certifications and everything else. Them being members of parliament and them having certain certifications does not necessarily speak to competence. But I'll leave it at that. The last question, Chair, I wanted to ask, does the DM and DG realize that some of the dismissals that have been executed by the board, the interim board that is currently sitting, may actually compromise the road accident fund? Now I'm talking from a process perspective, how they actually ended up at those dismissals. Did you realize that, did you see that there may be an issue there from a legal perspective? Thank you, Chair.
Which dismissals are those, just for the purposes of completeness and clarity?
There's a few senior managers that have been dismissed by, I think the dismissals were signed by the interim board chair, Mr. Brown.
My understanding, Chair, is that there have been disciplinary processes and there are suspensions. And they must follow the due process of a disciplinary process. I don't think that we can say remain in a position and not be investigated or disciplined if you are warranted to do so because it poses a risk to the ecosystem. What the entity has to do is mitigate against that, to do that process. So my understanding is that these are matters that are receiving the attention of due process.
Were they correctly, was the process to get to that disciplinary process correctly executed?
Well, I would not want to opine on that because the matter is subject to a process. Okay. It is not for me to say, but if the affected individuals have got issues around the process, they are at liberty and within their rights at the process to raise it. I think I would be placing the board in an invidious position. But what I am aware of is that the board, in its briefing to ourselves about issues in the entity, is certain that they have followed the necessary due process to ensure that the suspensions meet the legal muster. But and we believe that any DC should roll out as it should, and it is incumbent on the process to make a determination if there is something irregular. But from where I'm seated, the board has provided the assurance that they have done things correctly.
All right. Thank you very much. Deputy Minister, can I just just in the last 5 minutes, maybe one question from me, and I'll, for the sake of openness, I'll say where it comes from, so that we don't confuse, and I'll share what my observation has been around the appointment of board members historically. Right, so this is no comment on the interim board. We can canvass the interim board later when we discuss specific issues. But here's my observation. And my observation is that the RAF Act itself does not set out sufficient criteria to guide the minister on what type of people need to sit on the board. It does set out some skills, but I guess we could say with the benefit of hindsight, there are some clear areas which are lacking. So that is one. So that is from a combination of skills perspective, and I'd like you to just have a look at it. That's the first thing. The second thing is that having engaged with your with the DG's colleagues previously on processes previously followed by previous ministers, it also became clear that although the team, and that is the officials, do their best to guide the minister, what was shared with us in essence was that there is no consistent formula that gets used. My observation of this board, that these boards that we sat with, at least in terms of our historical conversations, the patterns of decision making, the information that gets presented and how it is presented, their interpretation of that information was sometimes exceptionally poor. And so that I don't speak in riddles, I will make examples so that you. So one of the things we were told yesterday was that the agenda of the board was approved by the chief executive. Now, I mean, you just think there is just no way on planet Earth where real people live, where any board member worth their salt allows that kind of thing to happen. So that's one example. The second example is, even when certain skills are put on the board, it would appear that there is no specific guidance on the level of experience, the areas of practice that person needed to be. So the previous board, the one that was disestablished as an example, as well as other boards, had lawyers on the board. I must tell you, given how much the Road Accident Fund gets smashed 6-0 on very critical matters that have become contentious, you really ask yourself, what were those lawyers on the board doing there? If they, you understand, we would ask questions like, did you seek legal advice? No. What? You are going to appeal a matter where a full bench of the High Court has had strident words about your decision, and you don't ask for legal opinion? Really? And they don't, right? So I just, and the last example that I will make is also just instances where the board does not appear to be able to make observations that reflect an appropriate level of management and leadership experience. So if you look at the 2023-2024 annual report tabled before Parliament, it screams of red flags, right? It's the vacancies that are on there. It's the acting roles where, someone is acting in roles where they're overseeing a budget that far exceeds their normal signing powers and so on, and that person should not be acting in that role. There is a board and the board doesn't know. So I want to ask a different version of the question Honorable Kupeka was saying, a slight variation on that. And that is, what is your view of the improvements in the selection criteria of board members? The final example I'll make is you also had board members who found no difficulty with the chief executive appointing other executives without their say-so at all. And the answer is that they're acting. Now, the signing powers of an acting person are the same as those of a permanent person. So I am not sure at which point the risk becomes less because somebody is acting. You understand? And some of these, when we look at the RAF Act is also not sufficiently specific in terms of when it says management, who does it mean? Is it executive members, etc., or is it any manager in the system, in which case there's just too many managers in the system? I know maybe I've over-explained, but I do want to ask you, with the benefit of your own experience over the last 18 months or so, what specific improvements do you believe are needed in the criteria for the appointment of board members?
No, thank you, Chair. No, your observation is correct. And in one way or the other, I think we may be ahead of the curve of that question now, because the Minister and myself have directed a process within DOT now wherein we actually constitute panels for interviewing boards as and when we appoint. So it is not just a matter of receiving, because you see we have to advertise for boards and so on. So it's not just a matter of receiving applications and then the spreadsheet is done and then we say, right, legal, finance, and choose. The short list, so that's why I was referring to what we call the long list and the short list. Long list is everyone who applies. Short list is then whittled down and we have an interview process, which is done outside the minister and myself, depending on where within the various branches of the department, aviation, railroad, maritime, integrated transport or public transport, wherever that board will fall in its purview with the SOC gap branch, then we interview and then they will make recommendations. It's part of the checks and balances we are putting in place to make sure that we have the right people. The only exception for the purposes of completeness, Chair, is the Road Traffic Management Corporation, because it is prescribing that the shareholders committee, which is the minister, myself, and the MSCs are responsible. So there's an interviewing panel constituted there of the MSCs, but of course with the support of of the department. So that's part of the work that we are doing. So we are paying a closer and specific attention to who is appointed onto boards. I was just trying to pull out here, Chair, if I may, that in the REF Act, in fact, it's very clear who must be appointed. So 10.1b, indicating at least 8 but not more than 12, is clear that we need fields of insurance, finance, medical service provision, law, accounting, actual sciences, or in matters relating to disabled persons, road users, commuters, or consumer groups. So we are endeavoring now, as we are engaged in the process of the new board, to actually appoint people who we believe are fit for purpose within what is prescribed. I would not want to speak to previous practices where we were not there, but what I can assure you of is that right now, as things stand, we are engaging in a bit more of a higher level engagement on the processes of boards. In fact, just again to sort of go along the same lines you have gone, there was a board where we arrived at the end of it and we realized that there may have been 1 or 2 lapses and we started that process again, so as not to fall into the trap of what you are alluding to. We are insisting with Minister that we need people who are fit for purpose. And we are insisting on the fact that people must be well versed in the material realities of the ecosystem upon which board they will be going into. One board, in fact, Chair, we didn't fill all the vacancies because we felt that a critical stakeholder or sector was not well represented, and we are trying to ensure that we advertise. So what I'm trying to say is that we are applying a bit more stringent process, and one which seeks to get the people whom are suited for what we want. And I think that the lessons we have learned is that if you don't do that, you have a situation of the tail wagging the dog within entities, because the centrality of the board is important as the accounting authority or accounting officer of an entity. And therefore, we need competence and experience and expertise within that space, so that combined they can be able to take the right decisions. Lastly, Chair, it is common cause that within the Road Accident Fund, you have had for the longest of time a situation of shopping for legal opinions. Until we find the right one, we will keep looking until we find the one that suits our agenda. And I'll leave it at that, Chair.
No, thanks, DM. I mean, the comment I will leave you with this, and I'm grateful that you've read the section of the RAF Act. Fortunately, it doesn't preclude you, but I would, with the benefit of our mutual understanding of the issues there, IT is missing, as an example. The Road Accident Fund suffers a lot financially from processes that don't work. So somebody with a process, industrial engineering, operations background, and so on. So the point I'm making is, I think it might be worthwhile for DG and his team, together with yourselves, to develop augmented criteria, given the holes in the core, in the section of the legislation. But I don't read it to preclude you from appointing these kind of people, because what I'm observing from the testimony that we've had is that the combination between investment decisions and process is poor. Something that the AG has raised. You invest in Bukamuso, which at the end might cost close to R1 billion, but at the same time there are legal risks, there are operational risks, there are other operational decisions being taken. But somebody who's got sufficient operational, production type operational experience would also tell you the equilibrium point between people and the technology. And that if you're going to make certain investments, then this is what it means for people. Just a real example from there. When the Road Accident Fund begins its Section 189 process, it says they're doing it because they've got a new technology. The project had not started yet. Now, if you have a board where somebody understands that IT projects take time and they get to a point where they work, there is no way that same board is going to authorize a Section 189 process, but that board did, to the detriment of the road accident. So let me leave it there. I mean, I've shared the observation with you, DM and DG. All I'm calling for is just being a bit more irritating around the criteria, if I may put it like that, so that the 50 billion that you trust the board to oversee it doesn't encounter the kind of problems we've seen.
You are absolutely correct. We are insisting on that kind of discipline in the exercise of the board's duties. In fact, you see, it takes me to what I started off with, this whole notion around the so-called interference, that I would not understand why any board would find it or term it to be interference when an executive authority pulls out your APP and draws your attention to your shortcomings or non-achievement of your APPs, right? So that you can be able to do better, as you say, in the management of the affairs of the entity. I just want to make an example here, Chair, because I think it is key, right, of what we are saying. So I want to pull out one example of a letter so that they can be now. So this is a letter that we dispatched to the Road Accident Fund on the 15th of December 2024 to the board. It says, it's heading to the chairperson, performance feedback for the second quarter report for 24-25 financial year. A report reference again herein submitted to the DOT on 31 October 24 indicates that REF set a total of 6 targets for the assessment period. Of these, 4 targets, or 67%, were successfully achieved, while 2 were not, which is 33%. I must address the concerns related to the targets that were not reached. The target to settle 15% of all new personal claims within 120 days was notably underachieved. Out of 12,360 claims lodged, only 1,064 were settled, resulting in a mere 6.39 achievement. This shortfall is concerning, especially given the critical role that the REF plays in providing timely support to claimants. So that's the nature of things we are raising with the board. And then the letter goes on. Now, that is what is then termed interference. And I think it's Honorable Gupega who was raising this particular matter around direct claimants. So I'm just citing one example of when we say we are communicating an engagement, you would therefore then expect that at that level, that board must be able to zoom into that key strategic space and answer it, why are we failing here, and respond to it. So that's why I vehemently reject the notion and the allegation that was presented here by the previous board that we are interfering. Thank you.
Thanks very much, DM. We've reached our lunch hour. Honorable members, would 2 o'clock be fine to return? Yeah, okay. Shall we reconvene at 2 o'clock? Thanks very much.
You lock here, Chair, or must we take our things?
But there's always somebody here.
I must take it.
Colleagues from DOT, so it's not just Honorable Member DM who's allowed in the canteen, you also are. Honorable members, welcome back, and Honorable DM and colleagues from DOT. So am I the only one who thinks the aircon is a little bit strong? Yes. Nah? It's a little bit strong. So can we ask that they move it up just 1 degree up? Yo. Okay, no, we don't want that, Honorable Neil May. So thanks very much, colleagues. No, just one degree up. It makes a big difference, especially when there are people in the room. Then it will make a difference. So, no, thank you very much, Honorable Madlala. It's your turn.
Thank you, Chair. And greetings to the delegation from the Department of Transport, to the colleagues and our support. I'm going to ask the Deputy Minister one question, but it's going to be sort of a broad question, which will be accompanied by a comment. So I will try and make emphasis on areas that are questions. But this is what I want to first say, Deputy Minister, because you started by responding to some issues relating to my name when you were addressing Honorable Gupega. We cannot fix problems with the same mentality we used to create them. It is not going to be practical to do so. And the public must never be misled or misinformed. But in the interest of transparency, this committee has a TikTok page, which is a social media page. Individual members have got their social media pages. There was no dubious intention in sharing the appointment and the qualifications of people, unless there's an allegation that particular information there was incorrect. But in this case, it was in reference to people that were appointed, which is a factual issue, and that they've got a certificate, which is a factual issue. No other addition was made beside the video quoted and the exact matter. So I don't think that it is correct to make an assertion that the intention was to undermine people. When the department goes and appoints someone with a certificate, who comes here and says he's not sure if it's an NQF level 6 or 7, only to find that it's actually an attendance certificate. And when we say exactly that to the public, that obviously views these proceedings. It cannot be then interpreted as us attempting to undermine a person. And I think we should not shy away from facts. It's very important that the public is aware. And I think that's part of the reason why these things are broadcasted. So let me couple that with the questions that I have. Maybe let me start with your presentation. On slide 11 of your presentation, which is bullet point 2, you say that the minister is, however, not satisfied. It's in relation with the interim board. The minister is, however, not satisfied that the nominated candidates collectively meet the skills, expertise, and experience requirement prescribed in section 10.1b of the RAF Act. Accordingly, the minister may opt to re-advertise or call for further nomination of candidates. However, candidates who were previously nominated may be reconsidered. This is a presentation from the department, slide 11, bullet point 5.4, relating to the appointment of the interim board, where you are saying that the minister is not satisfied with the nominated candidate collectives, that the nominated candidate collectively meet the skill set. So what we then express as a concern around whether the Act permits around the skill set of incumbents, interim board members, is the same expression that you are expressing as a department, that you do not think collectively they meet the skill set. And I think that is very important. But it also shows itself in terms of the decisions that I want you to maybe take us through the opinion of the department on.
My apologies, Chair. Just for the purposes of following, I'm trying to find the point he's referring to on the presentation, if you can repeat.
It's page 11.
So is it slide 11?
Slide 11, yeah.
Yeah, so that, yeah, slide 11, yes.
No, my apologies. I thought you would have known your presentation.
And I'm
So-
trying to find your page. I know the presentation.
Oh, all
I'm trying
right,
to
no
find the
problem.
page.
Thank you. So I'm saying that then the reflection of the question of the competence of the board further reflects itself in some of the decisions that the board has had to take. For example, which I want you maybe to then respond on. What has been the reaction of the department in terms of the board's decision to appoint an acting CEO from outside the entity? That the board correctly corrected. But that decision for me, it's at a very basic governance issue, very basic understanding of what should and should not be done. And it was corrected because the legal opinion advised accordingly. And I'm not a legal person, but I know for a fact that you cannot just appoint someone who is an ex-employee of an entity to come and act. Because you act because you have got a substantive position. It could be from a different entity or seconded, but it should be within one government. You can't be from outside. And that's a decision that this board has had to take. Further to that, the CEO confirmed yesterday that he is the one who signed suspension letters of the executive because there was an absence of an acting CEO during the space. And in my understanding of governance issues, council or board cannot be the one executing operational responsibilities. That is the responsibility of executive management. And there should have not been a lull period or in a vacuum where there is no one acting to be able to then sign suspension letters on behalf of the subordinates to the post of the CEO. And there are some of the decisions that I think the board has taken, which reflects obviously on the concern of the skill set and the capacity levels of the members of this very interim board. So let me maybe just add one issue that you can respond to, and then we'll further deal with other issues preceding to that. So the concern raised by the minister, and I think sitting here, I would say the minister, even though here it says specifically the minister, but if you can't answer, then it's fine. The question is, why did the minister continue to appoint, despite the concern of an interim, of the skill set? Because I understand this was a headhunting process, so it's not like there were limited applications. So the minister or the ministry went on and headhunted people with certificates of attendance and people with a skill set that the ministry is saying is not comfortable with, that they meet the collective required capacity. Why proceed to appoint those people? Let me pause there for now. Thank you, Chair.
Thank you, Chair. I suppose it may be a matter of interpretation or misreading. That section does not refer to the interim board. It refers to the process we are currently undertaking to appoint a board. Now, that's why I was trying to make sure that we are on the same page. On the 10th of September 2025, the minister published the list of nominees and names and nominators received in response to the invitation in national newspapers and government gazette required by section 10(9)B of the REF Act. The interim board was already in place then. The minister is, however, not satisfied that the nominated candidates, and that's in reference to the bullet point above, so that's not in reference to the interim board, and the situation may also therefore necessitate the extension of the board, the interim board. So I think maybe just to help Honorable Madlala distinguish between the two, there are two processes at play. When we dissolved the board, we had to put in place an interim board, but begin a process, the normal process, with the added features now that we have built into the system of how we appoint boards. And the list was published. It can be furnished to the committee of what we received when we called for nominations, which we are required to publish. That is where we are not satisfied about the nominees. And hence then what we have done is to rerun the calls for nomination, to broaden the scope and encourage eligible South Africans to apply, and we'll put them through the process I outlined before lunch, which will then deal with the skill set and the areas. I think the chair was adding one as well, but the due process will follow. Thank you, Chair.
Thank you, DM. And I think let me further go into now the specific questions that I packaged together with the issue.
So there's a
Yeah.
question around the acting CEO that he raised, which my apologies. No, obviously, in an environment as though in the time in which we were operating in, it arose that the previous board suspended the CEO, you will recall. An acting CEO was appointed, who he himself then subsequently was suspended alongside the other members that Honorable Ngubheka was referring to earlier on. The board undertook a process to appoint an acting CEO. And on the broader assessment, however the process and rationale may have been packaged, and other borrowed experience that they looked into in their and in the briefing note they sent to us, we maintained the view that an acting CEO would have to, if we were getting someone from outside, that would have to have gone through a cabinet process amongst others, and it had not done so. And therefore, amongst the other factors, we were therefore not agreeable to that. And the board undertook an exercise to locate a CEO within the institution, whilst at the same time I considered, Chair, whether we could find a person suitable enough from the other entities that we could have seconded. We did consider that option, but we arrived at agreeing that the board must look for someone internally, of which they did, and that process was rectified accordingly, hence the acting CEO as we have him now. Thank you.
Thank you. I think there are specific questions maybe that I would need to get answers from. I think it's common cause that the board took an incorrect decision, and it's good that the department stood firm that the process itself could not enable for such a decision to be taken, and hence the decision was corrected. But the point I'm driving relates to the feeling of the department around the capacity of the interim board, because that is the bone of contention in terms of the context of my questions. I note that I could have been misled by the subtopic in terms of interpreting this to be about the interim board, and you have expressed yourself, and the view of the minister is clear. So what is the view of the department around this current interim board skill set and capabilities to execute the mandate, given the decision that it has taken, that you guys had to send back to say, no, this cannot be? And there was one question in relation to that appointment of the acting CEO. But then the second question was, it would be interesting to hear from yourselves how you interpret the issue of the chair of the board signing suspension letters of executives that report to the CEO. And when he was sitting here, he said he did that because there was no acting CEO at the point. We know the historical background. And I'm saying that in the first instance, there should have not been a lull period. In the period when you suspend someone, you immediately appoint somebody as an accounting officer, but you do not usurp powers as an oversight committee with the fiduciary responsibility on governance issues of operational matters, that where you find yourself then operationalizing issues that are supposed to be dealt with by the CEO. So maybe just those two questions in terms of your view or the view of the department. Thank you.
I think I like the former term of the view, because feeling about it is not a thing. Chair, we've got confidence in the interim board, and we have got confidence that they are stabilizing the entity and restoring a culture which is conducive for the fulfillment of the core mandate and function of the Road Accident Fund, to, amongst others, avoid mission drift, to ensure that workers are working in an environment where they can perform optimally, and that we are paying claimants. We are dealing with the historical backlog, and they are assisting us navigate a difficult transition period which has characterized the road accident fund. Chair, the reality is this. If there's anybody who believes that all was well at REF, then they would need their head read. And if there's anybody who believes that since the changes we have made, there hasn't been an improvement, they would need their head read. The whole point of the decisions we have taken was to turn the institution around. I can tell you, Honorable Madlala, amongst others, that the reports of the 6th and 5th Parliament in Engage, and specifically the 6th, a culture of fear dominated REF for workers. I can tell you that when this Parliament sought to undertake an oversight visit, I believe you were there on Friday. I'm not sure if you were in attendance. But I can assure you that you probably received a far more warmer reception than the former committee did, where amongst others, everything we did then, we were tailed by security detail, wanting to listen in on what you are saying, not yourself, but the workers. I can tell you now that we have been saddled with the situation at REF, which has been very difficult for workers. And I encouraged the board, by the way, when I met with them to say, can you take the time to listen to your workers? Don't listen to me, because I've always avoided a situation wherein I transplant my previous experience as the alpha and omega of my current interaction and engagement with the entity. They saw no need for it. But the report back we are receiving now, workers are doing better, workers are functional. Above and beyond that, there was an abuse of disciplinary processes. People would be subjected to dubious charges and processes. They would appeal, they would win their appeals, and there would be a resistance within the institution to adhere to those findings. The whole ecosystem was contaminated, and I'm confident that the board currently right now is helping us turn things around. My last point is this. For the purposes of what we are doing, it must also be understood that this is an interim board. The operative word is interim. Ours is to appoint a substantive board across the due processes which we have outlined here and as the Act prescribes, and we are committed, Chair. But what we're not going to do is appoint a board for the sake of appointing a board. So what I'm trying to say, Honorable Madlala, yes, I can concede to you that there may have been issues around how the acting CEO was appointed. But where I take comfort is a board that is responsive when issues are pointed out to it and they correct it, something which had not been prevalent. And one prime example is on this issue of the accounting standards. The Accountant General, the Auditor General, the Accounting Standards Board, Parliament, the Ministry, the Department, all pointed to the fact that this accounting standard was incorrect. And 11 million rands later, we find that we had wasted time and wasted money. So what's the point? The point I'm trying to say is that the REF of yesterday is far more different than the REF of today, and credit must go to the board and the decisions we have taken.
Thank you.
So thanks very much, DM. So may I please intervene on behalf of the members? So I know you want to give us a comprehensive answer. My concern is that we'll only deal with a few questions, and then so if you can have a consideration as to time, so that we can fit in as many questions as possible.
Thank you, Chair.
Madlala, so I'll indulge you 2 extra questions because you are on 18 minutes. But Ask a question, get an answer, and then ask another one, and then we'll. That's why I was making the
The
intervention.
deputy minister gave me a political response deliberately. There's no question around the disaster situation RAF was at. And we commended the board for the efforts they are making. We commend the department equally for that. But as part of this process that we have started some months ago, what is important is to draw lessons from what were the issues or what were the problems. And my own conclusion is the very fact that what the then CEO did under a board that was appointed by a minister, and there was a standing committee on public accounts and a portfolio committee on transport during the entire phase of this quagmire transpiring within an entity. And as we then move forward, we must be able to ensure that whilst dealing with the overwhelming challenges that we are trying to transition out of, we do not reinvent the same problems or create particular patterns that may land us into the same space, because we don't want to see that entity in the same space in years to come. But nevertheless, because of the time limitation, I would accept the response, even though it did not answer specifically to whether the department feels confident about the skill set capacity of the interim board. The performance, yes, it's one thing that, in fact, we are measuring, if we measure performance against the previous situation, we are measuring ourselves against bare minimum. Bare minimum. That likely any probability would have been that anyone would have been able to make some impact in that space. So we don't want to do that. We want to measure ourselves against best practices and against what we could do at our maximum capacity within the available resources of the country, financially, human resource capacities, board experiences that we have in the pool of the country to manage such a multi-billion institution. And that is where we should pitch ourselves and then measure ourselves. But let me just ask one direct question. The CEO position, you said the minister said that it's got a file. The board said they finished it quickly, as quick as they've never done anything before. I think they said around November or something last year. And they were sitting in February today. Maybe can we get the reasons for the delay in filling that post? Maybe a tentative commitment, or if there is one. Thank you.
Thank you, Chair. The response certainly was not political. The response is factual. Because I indicated that we've got confidence in the board, and I was enumerating the reasons why we've got confidence in the interim board. It's not a political response, but even in the event that it probably was, this is a political platform. That's what Parliament is. So that may be another thing. But what I'm going to endeavor to do, Chair, is to advance the facts and the realities of the situation. The second point refers to the silent insinuation around previous challenges within the board. I want to just share an anecdote which may help the situation. The board that was dissolved had individuals from a previous board that had expired. And the issues that this committee is traversing were traversed. And the only limitation, it was time in order to embark on the kind of exercise that the board, that the committee is doing now in the previous parliament. Can assure you that this inquiry, as I said last year, is important and we support it and is in fact long overdue. Had time allowed, it would have been actually undertaken. And lastly, Chair, is that when you have a situation of, in the previous board when they appeared, where if you ask questions, then they say, that chairperson is chauvinistic and is bullying women on key questions of accountability. It tells you everything you needed to know about what kind of capacity we were dealing with. So I'm glad we are here. And I can assure the Honorable Madlala we are drawing lessons from everything. And that is why I'm pointing to the fact that the interim board, an issue was raised with them and the board was responsive to rectify it. That has to count for something, because what we could have easily had is people digging in, as we've had in the past. So yes, we've got confidence in the board. Lastly, Chair, yes, the interim board has concluded its processes for the CEO position. We met with the minister. We discussed the report. We had questions. We have sent questions to them. and the signed off responses have reached us. We'll consider them and take it forward from there. What has to happen next, of course, is yay or nay. We will engage with the board. It goes to cabinet and all the other necessary clearances that need. So this is a process, and the point is that it's a process underway. What I can assure you of is that it's not left to the whatever, at the earliest possible opportunity, which will include the cabinet cycle periods as well.
All right, thank you. This is my last question, Chair. You said 2. So the term of the board is ending this week, I think on the 7th of February, if I'm not mistaken. I just want to check. I know that we have not been told if it's going to be extended or there's going to be an advert and all of that. I just want to get a sense that, is the department looking into a process of re-evaluating the performance of the board against the terms of reference and making in order to have a scientific process to arrive at a decision whether to extend or to advertise, and looking at the time frame, if the intention would be to advertise, the advert would have gone out, because we don't want, there can't be a lull period between the 7th. So there should either be a process currently of one of the two, to look into the terms of reference, look into the report and the scientific evaluation of its performance, and whether then an extension can be considered, or there should be an advert out. You don't have to say which one is in place, because I've not received any information with that regard, but can we just get an assurance that there is a process in place to ensure that come the 8th, we are still going to have a board, an interim board in this particular instant, a draft, whether this one or another one appointed? That's the last question, Chair. Thank you.
I can assure the committee that come the 8th, the Road Accident Fund will have a board in place, an interim board, as per the processes that ordinarily unfold. Excuse me, when we appoint a board. We are not going to allow for a vacuum or a lacuna, and once we have made a determination, we will announce that determination and its outcomes thereof.
All right, thanks very much, DM. Thanks, Honorable Madlala. May I please ask Honorable Maduna?
No, abonge sihlalo. Abulise kwithimba lakho. Our fellow MPs, Deputy Minister nethimba lakhe. Thanks. I think the first thing one would want to establish, just again, I know you might have touched it, DG, a bit, but I just want to check. Firstly, how long was the previous board of RAF without someone from the shareholder representative?
Thank you very much. I'm just trying to make sure, because I think it is in the presentation. Mr. Ramansi left towards the end of 24, 25, and then, no, in July 2024. And then we made submissions for the appointment of an official. For obvious reasons, there had to be discussions around the suitable person. In fact, the initially nominated person had to be withdrawn because of a perceived conflict, being the person doing oversight. It was coming from the over. So it could be a period of 11 months that there was no shareholders representative.
So we would make an assumption that before that, RAF the department was receiving reports in of what is happening in the board?
There is a fully fledged branch, Charles, responsible for entity oversight. There are performance report appraisals for quarterly reports. One of the analyses is the letter read by the Deputy Minister earlier on around areas of non-performance, what we say. It could be one of those letters that would have been processed and are not processed by shareholders' representative. I indicated the role of the shareholders' representative. Oversight, performance, financial and non-financial, is done elsewhere at a branch called SOC GAP, which is the oversight branch. Thank you.
No, thanks. What I'm trying to establish is there no coordination between the work the shareholder representative is doing or their observation and the oversight branch?
Ordinarily there is and there should be, but we have indicated that the legislated work basically happens at oversight. Except for that, the minister shall have a board and a shareholder representative, which roles we were trying to clarify earlier on, and the discussions that ensued called for strengthened shareholders representative role within the board. And their role is to come back and report on board meetings and report on other activities if they are on subcommittees with what we call back to office reports. But the statutory reports which we interrogate performance is done through the SOC GAP.
Okay, so I would assume that you would have an existing report or the previous configuration of government. I think it was under public enterprises. That would indicate that the CEO of RAF would have approved the agenda of board and of audit committee. You would have a report generally that would highlight such things that are happening in the organization. Or let us just say governance processes.
I wouldn't know what would be in the report or what would have been in a particular report unless we are specifically directed to that report. But the matter of the CEO approving the agenda, I also heard it for the first time yesterday from the previous chairperson. I mean, from the current chairperson talking about what was happening in the previous setup. That's the one thing. Then the second thing is, if there are those issues, that would be the issues that would not find in the performance report, but would find in governance issues that would be the responsibility of the shareholder rep.
Sorry.
I think you can answer.
No, I just want to clarify, REF was never part of the Department of Public Enterprises ecosystem. So they've always been part of DOT. The entities we got from Department of Public Enterprises was Transnet, SAA, TNPA, and South African Express. That four, yes. So the other entities such as PRASA, REF, RTMC had always been part of the only changes that arose in the department was when, well, not only, but amongst others, when we received staff from DPE, which would have then broadened the scope of work within the PEO.
So, Tichi, I think then, because what I'm trying to establish is that the department had a role to play. I believe that that is the lowest you could ever see in good governance, when the CEO controls the audit committee, which means in turn it controls the internal audit. And let me give you my observation before I ask what I want to ask, because I want the department to also take its responsibility in the mess that was a draft. When we spoke to the board, we established after some time that the board could not receive the report of Mora that started the crisis. That would have told the RAF that it's not possible for you to leave a grab and use IPSAS 42. The report further very detailed tell them that in South Africa the reasons why we are using grab, all of us, is because the minute or the treasurer is using grab to report. So if we are using IPSAS, it's not going to be it's not going to be in line with what everyone else is using. Now that report is discarded from the directive of the CEO, giving it to the CFO, and then there was a discussion with the chief internal audit, and then they agreed to withdraw the report. That would have then resulted into sourcing from PwC, but with a different scope now. Now the question I was asking them, where I established that there was a problem at RAF. It's when I was asking them, how did you and the CEO end up instructing internal audit to reverse or withdraw a report? It does not happen, because the CEO himself must receive that report from the audit committee, not from the chief internal audit. Now, that's why I established that there was a problem. The power that CEO had was way too much. So yesterday when I established that he was even approving the agendas, that is when then I established that government was really at the low, good government was nowhere there. It was at the lowest. So now I want to establish, how did the department with the shareholder, with the oversight, not pick up these issues?
Then maybe I need to go back a little bit. On the issue of the accounting standards, when it started, we did have a shareholder rep. Mr. Ramanzi was still there. And we took issue. I think there's no less than 4 letters coming out of the former Minister Mbalula. There were letters coming from the former Minister Chikunga, and there were other numerous letters coming from the current minister. So we have always been now. I explained the issue of shareholders' responsibility versus that of the board. That the shareholder invests in a company, appoints a board to direct the affairs of the company. And even the board, where you have the majority being non-executive directors, you then rely on the executive management to deal with the work. That does not abdicate the responsibility of those that are supposed to take on certain tasks, and those tasks, if they are not delegated, they need to be performed. When we got wind of what was happening around the accounting standards, we inquired, and we approached the entity via the boards from the minister. And they started at the board level indicating how they interpret the ASB guidelines. But the message has always been that it would be very much desirable to get out of a court process and settle with the AG. So that has always been the message. Let's come to the issue of the setting up of the agenda. I would not know how the board would have run their affairs personally, but I think that if at the time the agenda, when you approach a meeting, that's drawn from experience of how companies work, are dealt with and are being given both from management side and both from the board to the SOC, company secretary, COSEC. And the company secretary compile an agenda and take it to the chairperson to approve. And that is what needs and should happen.
No, thanks.
If I may, boss, I think maybe because UDG is giving the one side, I want to add the other. Let's just be point blank with the committee. The board was recalcitrant. That's just the long and short of it. And against all advice and guidance from the bodies I have listed prior, was hell-bent on continuing with this disastrous fishing expedition of an accounting standard that was not approved. I can dare say that in the first board meeting, I raised this matter very sharply, and they said they will come back to me in a month's time or so with the response, because that's just the long and short of it. So whatever may have been said, Honorable Maduna, by ourselves and predecessors, they were recalcitrant. They dug in, and this was the hill they were prepared to die on. So I'm sure you'd want to come at it at different angles, just for the purposes of whatever. In the final analysis, it was only in June 2025 when the writing was on the wall that our patience had run below its thinnest, that they said, no, give us 14 days for us to go and consider a responsible way upon which we can withdraw from the Concord action. And because at that time things had, for all intents and purposes, within the board itself and in its ecosystem, collapsed. But in all the periods you traverse, we were dealing with the recalcitrant, stubborn board. Thank you.
In 2022, because I want us DM. That's why I'm trying to be very patient and slow about this, because we need to fix also the department oversight and also what the shareholder is doing. They must do their job. Now, in 2022, the minister goes on media. I think it was around the 4th of March or so, but it was before AG would have completed the audit. This would have been after the implementation of this IPSAS 42. He announces that RAF has been turned around, the liabilities of RAFs have significantly reduced, and so on and so on. Now I want to establish, Tishi, who advised the minister that it was okay to go to the media and announce before the results were even audited by AG? That's one, my question. Two, what was the role of the oversight, your oversight branch in that mess that the minister was being put under? Because I'm asking this, Deputy Minister, because you might find yourself in the same issue tomorrow. Thank you.
Now, thank you very much. Maybe, Honorable Chair, because I took an oath, this is an area I would not want to traverse. I was not the acting DG. I was minding my business with buses and taxis in the public transport branch. That's a fact. Now, as part of the department, the recollection of what we were told was happening is that RAF converted, unbeknown to the minister at the time, to IPSA, and then which reduced the liability to up to about 10% of what was actually was. And then the RAF was the one that approached the minister at the time to indicate that the task you have given us of turning things around, these are the results. I would not know if the minister did ask the then DG at the time on what his thoughts are based on that. But that was the, if you like, the news coming out of RAF portrayed as positive news, and then the minister articulating the message to the country. We might have to find out if there was an opinion sought, an opinion given around that time. We'll have to go to the records.
Just, sorry, Mama Duna, just to And Chair, here's the sequence of events as I've, in preparation, trying to look at it. So the directive from the then minister was for REF to deal with its liability. Never determined or dictated how. He said, this is one focus area I want you to look at. REF then came back with this news of a liability that had been dealt with. And I dare say by stealth, that's how it was done. And the minister's attention was then drawn to this issue by the then your immediate predecessor committee to this particular fact. And I think correspondence will also be on the record. And then the response from the minister was to say, when I said deal with the liability, this is not how I meant. So that's all on record, that he pointed that out to say, this is not how I meant you to deal with this. But that is the ingenious, colorful accounting that was employed by REF to deal with this. So when it happened, the minister's attention was drawn by your immediate predecessor committee that this is what has happened, and hence then the instruction given to say, don't do this, come out of court, don't fight AG, yada, yada, yada. And they stuck to their guns.
19 minutes, Honorable Madun.
How, Slalo.
Oh, please ask. Ask. I'll ask a follow-up. I have a follow-up on your line of question.
Because I have a new issue that I've not started, that I would wanted us to converse with the department. But it's fine.
Just place it on the
follow
table.
up.
Place it on the
It's fine
table.
when we follow up, because I'm still on this issue. Minister, maybe I think this is what we must establish, because I'm trying to establish the protocol in terms of how entities they would report to the department. Then obviously the department would then prepare everything for the minister, especially when it comes to public. Now, you see, when a minister will go to media and make pronouncement on a performance of an entity before even the AG complete their audit, that's why I have a problem. Because now, these have not been tested. That's why I'm saying that even the minister then was misled. That is where my observations are coming from. Now, what I'm trying to establish here, DG, is how does this process work? Because I believe that an entity of your department does not communicate directly with the minister. I'm not sure if you get what I'm trying to establish.
Chair, let me put it this way. I suppose different ministers operate differently. Leadership, engagement, style. I have tried to present here the standard operating procedure that Minister Creasy and myself have engaged in. And that is to receive detailed, amongst others rather, is to receive detailed reports from the PO/SOC-GAP, depending which period you're looking at, and to go through the recommendations. I was sharing with the chair during lunch that we have got a conveyor belt of decision-making and decision processing in the department. And that is why you would find there's more correspondence now and says whether he had communicated it publicly or whenever, the manner in which the report, or rather the reality of the reduction of the liability was dealt with was wrong, and the minister was misled by the board and the entity. And subsequently, when that was brought to his attention, amongst others, I brought it to his attention that this is what we are dealing with. He spoke to the board to say, this is not how I wanted this matter to be dealt with. But I think we here cannot speak for former Minister Mbalula and his engagements and non-engagements with the media and what would have triggered him to have said that. You would have to put that to him. What we have tried to do is to be keenly focused or hands-on on the oversight matters. Lastly, Chair, is around the role of departmental reps, shareholder reps on boards. And I've indicated earlier on that on key policy matters, we have instructed them to report that in real time to the shareholder before even these quarterly reports come through. We are recalibrating how they function, and we are entrenching them as an assurance layer within the SOC GAP branch and within the ministry itself. And of course, what I must also advance, Chair, is that one, this is not remunerated work that these shareholder representatives do. Isicelo nje ifavor siyacela usiyele lapha. So when, and that may also account for the period in which we did not have a departmental rep, because as the DG says, nominations were made. Some we deemed not to be appropriate, some was conflict of interest, and others did not even arrive at being a submission because when the individual concerned was approached, they were not agreeable to want to take on that responsibility. In the broader reforms, therefore, is to look at how we actually place our shareholder reps, and that is work that is underway. What I can say is there's an improvement in recent months in how shareholder representatives are reporting on the key areas in which you are speaking to, so that we can be ahead of the curve. Thank you.
Thanks very much, Honorable Matuna. Honorable Skosana, I beg your indulgence. I just want to ask some questions along this line. Just for my education, must the shareholder representative always be an employee of the department, or is the minister at liberty to choose an appropriate person for the role, or must it be somebody who's from the department?
Chair, the Act says the Director General of Transport or any senior officer in the Department of Transport designated by him or her.
Yes, thank you. Actually, thanks for the reminder. So one of the things I think to both members Madlala and Maduna's point is that we must maybe just think about what legislative changes may be necessary to do an effective job. And I'll be frank here. My understanding of the value of having a shareholder representative is that they've got to be able to assess on behalf of the minister who has 1,000 entities to oversee whether the board is performing as a board should. If such a person does not have the depth of experience to sit on a board, I think it is fanciful to expect them to make that assessment. That suspicion for me is also confirmed by the fact that so much goes wrong. And as I indicated, it's not just at the Road Accident Fund, so this is not peculiar to the Department of Transport. I made the PIC as an example. That things go so wrong that the minister gets to the point of eventually, while being yelled at by Parliament and the public, of eventually dissolving the board. And in hindsight, there are many steps over maybe the preceding 2 years where the minister could have intervened. The sense I get out of the RAF is that it suffered greatly from that problem. So in other words, in considering the shareholder representative, the Director General must, I would think, pick someone who of their own could be on that board as a member. Because some of the things we subsequently, I'm putting this proposition to you, DM, not to insult anyone, and I really don't want it to be taken that way, but to just say, having had regard of the performance of shareholder representatives who are described in this way in legislation, I'm inclined to say the description is unhelpful to the minister who has to come and clean the mess later on. What is your opinion on that?
Chair, I think more broadly, the issue is what do we expect of the departmental reps? Because in the first instance, the board is appointed by the minister, right? And then, so one would assume, or one would have a legitimate expectation that even before you arrive at a departmental rep, any board of an entity wanting to engage in a substantive policy interaction, exchange, whatever, would ordinarily want to communicate that with the shareholder, with the minister. So I'm just saying, as a point of departure, the shareholder representative is an added layer and should be a conduit of direct flow of information and exchanges outside the normal established protocols of the submission of reports. So therefore, you are correct that it must be somebody who has got the wherewithal to understand what they are traversing, and that is what we tried to establish here at REF when we were looking for a departmental rep. You will also recall that the DG then also resigned as well in the midst of all these transition periods, right? Acting DG has been in the post for a while now, or not a while, but he's been acting as we undergo that process. So it coincided, Chair, I think, for whatever reality, with a lot of transition. And we agree with you that these must be people who know what they are doing. They must have a granular understanding of the issues, and hence the exercise we have undertaken. I repeat it to echo your point, that how do these departmental reps add value to issues? And as I'm saying, I received a very substantive report in December from the current shareholder rep, EDREF, detailing issues, and I think that we will come out of the broader reforms we're trying to do in the department much stronger from a representation point of view, whether the legislation says internally or externally. But I think let's not lose sight of the fact that as a point of departure, ordinarily the board appointed first in itself, above and beyond the shareholder rep, must know what they're doing.
No, thanks very much, Deputy Minister. So I will leave you with this thought, and that is the lesson I think we keep learning is that when a system relies too much on the discretion of an incumbent, when you have the kind of person who is themselves risky or weak, the system falls apart, it fails, right? In the sense that if you don't have a rule or a guideline that guides every minister in terms of what criteria to use in picking a shareholder representative, you might have a minister who knows what a good shareholder representative is with a DG, or you might have one that does not know. And when you have one that does not know, the whole thing fails, which is why I am premising my question on on what the legislation says. The other part of the legislation we dealt with had to do with the skills set out in the RAF Act. Minister A may think, you know, we need certain types of skills and I'll include them. Another minister may say, I'm just following this, and the organization is left poor. So all I'm leaving with you, Deputy Minister, at this stage and the DG, is that I do think, because I know that everyone is invested in the RAPS bill, I think realistically, RAPS will begin to perform its work at some point in the future. Meanwhile, the Road Accident Fund continues to exist under the RAF Act, which in my view has several areas of, of improvement, which are a cause, which give rise to certain things that we may not like. So I just want to leave that with you and to say that perhaps we are leaving a little bit much to discretion, if that's okay. So Honorable Skosana.
Ngiyathokoza Sihlalo, and good afternoon to fellow members, the Deputy Minister, the DG and your team, and our support team and other stakeholders present. You know, we appreciate this opportunity to have an engagement with you, DM, and the DG, and we must indicate that we commend the good work that we have done in taking some steps to fix the RAF, including the dissolution of the former board, which in my view failed in its fiduciary responsibilities. The current interim board, they've explained or they've defined the situation at RAF as an organization in distress, financially unstable, poorly governed, and deeply affected by systemic fraud and corruption, which is a very worrying situation. However, we were noting, I think, the work that they've done so far, as per the report that they presented before us yesterday. However, I think there's still a lot that needs to be done. I think the mess is too much in that entity. So I don't think the interim board will be able to correct everything. I think some of the work will have to be done by the incoming board that will be appointed in due course. But I think we were noting that they've at least started to correct some of the things. I've got very few questions because some of the questions I think were expropriated without compensation by other members. The former board members that we met with last week, DM, I think they raised a concern about the fact that the minister never met with them. Though they understand that you are delegated by the minister to play oversight role in this particular entity, which is the RAF. But they are not happy that the minister never met with them even once, even for a meet and greet since the minister came into office. Well, which also I find it strange. And then, well, I pose a question to them to say, but then on your side, did you reach out to the minister? And then they said, yes, we have written a couple of letters to the minister, but unfortunately the minister never responded and never met with us. So it's something that they feel that the minister maybe didn't like them, something like that. Because they say we always see the minister with other board of other entities within the RAF family, I mean within the transport family, but we as the board of RAF, we never had an opportunity even just to meet with the minister. So I just want to find out from you, whether are you aware of that thing? Have you seen those letters? Have they raised that matter with you? Because I know that you have been with them in most of the times. Have they raised the concern that they would want to meet the minister? Or if they've written those letters, have you seen those letters? Have you had any conversation with the minister about her meeting with them?
Thank you very much, Chair. Look, let's start here. We are not a nanny ministry. Let me just be as frank as that, where people must feel liked or not liked. They must work. They've got a fiduciary responsibility in law to perform whatever it is that they need to perform. This thing of feelings, because it stems from assumptions, it stems from expectations, which may be neither here nor there about the core function. Here's the reality of it. When we were appointed, the minister and myself took the time to understand where we had been appointed to extensively. The medium-term development plan was developed, and we had a roadmap of what it is that every department must do. Honorable Skosana, we met all chairs and CEOs of boards, all of them, at a strat plan session that I chaired, me, and Minister presented there the roadmap we had agreed upon. After that meeting, I engaged with, not that day, as when it ended, with the former chair of the board of REF, because Minister at that meeting then informed all of them, this is how we have delineated the work. And REF is with the Deputy Minister. She wrote to me to that effect in August 2024, all the work she was delegating. It includes entities, it includes programs, it includes all sorts of things. The letter can be made available for clarity. So it was defined early on. So I thought I should clear that because, and she indicated that engage with the DM, I will engage with my entities, right? So that's point number one. The second and last point, Chair, is this. In the course of our work with the Minister, because I think this is important for the public record and yourselves, I can say without any fear of contradiction that there is no decision I have taken without speaking to Minister, and there is no decision she has taken without speaking to me. And that is one of the reasons why the department is so healthy right now, because we are able to work together with the Minister. We can have robust engagements with her, and we'll share ideas, and I fundamentally believe that I have adequately briefed the Minister on REF matters. I believe the department has adequately briefed the Minister through submissions and engagements. And so I think my assumption, Chair, this is my last point, my assumption is that if a minister and a deputy minister are not careful, individuals and boards and entities can drive a wedge and sow division. We will not allow that to happen. And my assumption with this thing, DM didn't like us, DM was hostile. What, when I go and cry off to minister, what I can assure you of, you would have gotten there and should have been very well briefed about all the issues you would have been complaining about. And I think this is a non-issue, Chairperson. They are trying to create amawongo. It's not there. So I assure you, Honourable Skosana, the minister is well briefed and well versed on ref matters, and that is why you will find in the presentation we make reference to the minister. Because if there's one thing I'm mindful of, see, so I'm not one of those overly ambitious DMs. One thing about me, I can be led. The lead of the ministry in the department is the minister. She has delegated work to me. And therefore, because I'm delegated, major decisions, I must run by her first. That is the clarity of the ecosystem. And that is the stability of the department. Thank you. So a listing of feelings, we're not here to be liked or not liked. We are here to work.
No, thank you very much, DM, for that response. Yeah, I was very much worried about that, because I think if people create an impression that they were not liked, I think they would then connect that to their dissolution, to say we were dissolved because even initially the minister did not like that. But thanks for clarifying it.
Honourable Skozan, sorry. Then if that is the case, if they were not liked, we could have dissolved them on arrival. We arrived in July 2024. In the midst of chaos, we tried to resolve the issues until they were dissolved in June 2025. For them to have stayed that long, after, Chair, can I just say, pleading, maybe let me put it that way, pleading with them. Guys, please don't do this. That is the extent to which it was. For the entire time we got there, the major issue we were raising with them was on the Sinenga. Minister, can I tell you, Minister then wrote to the board about this accounting, since I've got the letter here. You know what they said to her in response? But when we don't talk to you, we talk to the DM, Goba, you've delegated us to DM. What business do you have here? Now, on one hand, she didn't meet with us. Then she writes to them, and then for all intents and purposes, you tell her to go jump. No. I think let's elevate the standard of engagement and expectation. The board was being wholly unreasonable here.
No, thanks, dear. Now, with regards to the appointment of the new board, as reflected, I think, in slide 11, I think the second bullet that says, the minister is, however, not satisfied that the nominated candidates collectively meet the skills, expertise, and experience requirements prescribed in Section 10, subsection 1B of the RAF Act. Accordingly, the minister may opt to re-advertise and call for further nominations for candidates. However, candidates who were previously nominated may be reconsidered. So I just want to know, what is the firm position currently? Are you going to re-advertise or what? Because I think it should be clear by now, because the current board, the interim board is left with maybe 3 or 4 days. So it should be clear, what are you going to do? Are you going to re-advertise or what?
Yes, we will re-advertise, Chair. And above and beyond that, the concession you must make is, when we advertised at the time of the chaos. And generally, people with a professional outlook or reputational consideration would not want to come into a space where there was that kind of turbulence and uncertainty. And therefore, we have a limited pool upon which to consider. And hence the dissatisfaction that we have around that pool. I won't venture into other considerations because it's a long list of issues. We believe that we have stabilized the entity sufficiently enough to be able to draw the confidence of potential board members who would want to serve and add value. That pity period was not conducive in our outlook, and so and this is, I must also indicate, this is not to cast an aspersion on all the applicants. There are people there whom are appointable there, but what we don't want to do is just proceed on the basis of a limited pool. And we've not canvassed anybody to apply, so we will be re-advertising so that we can take the process forward. And then, of course, once we've received, we'll publish the names for comment.
No, thanks, dear. And then in your slide 10, I think in bullet 3, you are saying it is worth noting that Section 10 of the RAF Act does not make provision for the interim board. So I just want to find out how are you going to rectify that moving forward so that in future you are not questioned to say, but this thing of appointing interim board, it's not there in the Act. How are you planning to rectify that for future purposes?
Oh, yeah, no, DG phrases this better than me. DG, can you phrase it better? And then I like your phrase.
Thank you very much, Jim. Thank you very much for the question. I think we just need to indicate, we are saying there is a board, there is no acting board or interim board or whatever. There is a board, there is no acting board or interim board or whatever. But then, because the board was dissolved mid-term, it is a continuation of the board. It's like filling a vacancy on the board. So that happens anytime there is that vacancy. So this time around, the board, the members were dismissed and therefore replaced on an interim basis. So there is we have a legal opinion on that, and it is we are on the right track.
To add one thing, we subjected this process of the interim board to cabinet, the cabinet committee and cabinet, so that we could build in the checks and balances and avoid a situation where it was just us. So it went through a cabinet process as ordinarily is for any other board.
Okay, no, thanks. Yeah, my last question, Chair, is with regard to the issue of cancellation of NUMSA's recognition due to the so-called RAF's reclassification from road freight transport sector to social security sector. The matter which is currently in court. I want to know what is the attitude of the ministry regarding this particular matter. Because we met with NUMSA here, they feel very strong that that was an unfair process. There is no such a thing. Hence, they took the matter to court. But the other challenge connected to it is the fact that I think NUMSA was representing more than 70% of the workers there, with the remaining 30% being shared by NIHAU and those who don't have a union. So collectively, they share the remaining 30%. So NUMSA was representing 70%. And now the challenge is that even though NUMSA is currently not recognized, but those members who were NUMSA members, the majority of them, they still remain NUMSA members. However, they obviously don't enjoy the ordinary union representation because the organization does not recognize NUMSA. Yet these members, they remain NUMSA members, they pay subscription to NUMSA, so they are in between. on one part, they are members of the union. However, their union is not recognized. Therefore, it means their union can't represent them. So I don't know if the department was ever involved in this particular matter, whether NUMSA raised it with you at any point. And then currently, what is your view? Are you waiting for the court case to see the outcome of the court? Or are you intervening, or the interim board is going to intervene on this particular matter?
We have not in the ministry engaged with NUMSA on the matter. And secondly is to indicate that part of the mandate to the interim board in our efforts to stabilize is to look at all the material ecosystems that may have been affected by past decisions. So to apply a fresh set of eyes and make an assessment and a determination so that then we know where we stand. So if the matter, as you say, is in court, the board will have to apply itself to that. But as I'm saying, labor relations is one of the apex priorities we have presented to the board, and they will make a determination. But we have not, in the ministry, engaged with NUMSA, nor am I aware of any correspondence that may have come from NUMSA to this effect. So I would want to believe that it has to then receive the attention of as all other matters are, and we will look into it. DJ, I'm not sure if there are any papers that we may have been cited in as a DOT, but we are looking at, well, rather we've asked the board to look at the labor relations ecosystem in its material entirety, stabilize it and regularize it accordingly. Thank you.
One more, Honorable Scosa.
No, I'm done, Chair. Thank you.
Right, thank you very much, Honorable Pila.
Thank you, Chair.
Chair, I'm collecting everyone's time.
No, you are on Honorable Pila's time. Stop. No, I'm calling you to order, Honorable Member. You must ask that. No, you're on Honorable Pila's time. Please, let's reset Honorable Pila's clock. I am going to fine you. Honorable Pila, please go ahead.
Thank you, Chair. Maduna, you are disturbing me. We are in business now. Good afternoon, DM, DG, and the team. And good afternoon to everyone, including my brother, Honorable Esak. Let me start where Honorable Skosani ended on the issue of NUMSA as a union. When NUMSA was here last week, Tuesday, they reported to us that a lot of workers, or many of workers from road accident fund were suspended. A majority of the cases were not dealt with. Some of them were not found guilty. Some were dismissed. They also talk about the issue of 50 employees who were put on suspension for more than 36 months, which is 3 years. And that more than 200 employees were put on suspension. I just want to check with you, DM. How is the ministry assisting a road accident fund, especially the interim board, in assessing and reviewing dismissed and suspended RAF matters, RAF employees matters, who some of them were not found guilty of wrongdoing?
Thank you. Honorable Pila, we come from what I can term an era of terror within RAF and a blatant abuse of labor relations and employees. an environment that has not been conducive for work. And as I've indicated, part of the apex priorities we have placed for the board is to deal with labor relations. And so we are aware that there are cases of workers, and I think I made reference to one earlier on where if a determination was made, I think by CCMA, and the worker still not back at work. We receive the correspondence as well quite a lot. Employees call directly to say I'm at home and so on. And the expectation is the board must obviously facilitate a process of assessing case by case where this matter was, if it's still pending, concluded. If it's got a decision, implement either way, whatever that decision may have said, so that you provide a direction certainty to the worker. If you are going to appeal, then indicate that you're going to appeal. If you must reinstate, then reinstate. The board is busy with that. New cases are surfacing every day. So this will be part of the ongoing work that we will be doing at REF until we conclude all the issues. So the matter is receiving the attention, but obviously it's a case by case and merit by merit. What is it that we currently have before us? Thank you.
Thank you so much. DM, are you aware that there are employees who spend more than 600,000 on legal costs for the period of 12 months? I'm talking about employees who were suspended or are suspended from a road accident fund. And now, because the CCMA is about to conclude with the process, I think it will be the 5th and the 6th of February. There are some employees who want that process to be restarted. And those employees are crying that where will we find another 600,000 for the next coming 12 months when the process is restarted? Thank you.
Well, I am aware that such processes come at a cost. I am aware that by some of the issues that have been raised with me, that employees are in debt and so on. But our position remains that those matters in the ordinary course of work, because they are an employer-employee relationship, must be subjected to the due processes of the labor relations protocols in their material entirety. And that is what we have asked the board to do. And lastly, to say, we have asked that the entity move with speed, urgency, with the processes, so that we can close that chapter.
Thank you. Yesterday we were with the interim board members together with the executive. The acting CEO, I saw him for the first time yesterday, but when doing my research, I found that the acting CEO of RAF is a chief audit executive. Am I correct?
Substantively, that's his post before assuming acting. So he's the chief internal auditor.
So since he's now busy working and heading all operations of the road accident fund, are you expecting him to audit his processes that he was involved with? Will that be a good governance?
Honorable Bila, we are saddled with a very difficult situation. Executives at REF have been suspended because of pending disciplinary processes and the associated circumstances that come with the suspension. That's part one. And therefore, because of that, as I was trying to traverse Honorable Madlala's questions, is to say we had a limited scope upon which we could choose from who could act. And I think that it is not a decision that the board took lightly. And I think there is now an acting chief internal auditor, so that the acting CEO does not have a polygamous arrangement of two positions. My understanding is that he is not in the chief internal auditor's post as things stand now. He's in the acting CEO's post, and I would want to believe that it is also a interim short-term arrangement until we appoint a CEO. What I can confirm for the record, without delving into that he is not somebody who applied for the CEO position either. And I think you had seen him before. He's been part of our meetings here when we've come before you. Thanks, Chair.
I thought maybe it will be an issue of a referee and a player at the very same time, which will make it difficult. Last question, Honorable Chair. Yesterday we asked the board, when are we expecting the new CEO to be appointed? Then they said the DM, because he will be part of your meeting tomorrow. They were referring to today. Is the rightful person to be asked this question? So I'm asking now that when can we expect the CEO and a full complement of full-time executives that will be steering the organization? Thank you.
As I've indicated, Honorable Pila, the appointment process is in motion as we speak now, and we will do what is expected of us, including but not limited to undergoing the cabinet process for appointment. So that is something that we will do. Of course, we've interacted with the board because there's been clarities that we have sought from them. The whole point is really to make sure that we do everything right and conclude. On the executives, I think we also need to adopt what I call a hamba-kahle approach. In this context, there's disciplinary matters. They must run their course. And where additional support is required, the entity will speak to us and we will see how we can actually provide it. And I think lastly, on that question, was I think it's key. Chair, you would know from previous engagements here that it seemed as if the organogram in one way or the other had been messed up. And a lot of shifting was done, this office there, this function there. Legal and governance was clumped into one. I know there's the constant running joke now, which is not a laughing matter, but I say joke loosely, because in meetings you would always have it flippantly said where the head of legal did not have a legal background. So those are the things we are dealing with. So we still need to clean the ecosystem as well and rationalize it correctly to make sure that it is a structure that is fit for purpose, because there was a lot of shuffling of roles and responsibilities. It was almost like a Tetris kind of approach that was done. So the work around executives is ongoing and the disciplinary processes are underway. And then, of course, above and beyond that, there's still the SIU investigation, which in itself must be concluded so that we can be in receipt of the findings and be able to apply the remedial action thereof. And if it touches on executives, then that's another matter. So we are still awaiting that, and I hope that the SIU can move with speed to conclude it. And that is why well, at least on the first part, we've also, as I've said, applied for an expansion of the proclamation, because a lot has subsequently gone wrong, and we will be in a position to at least receive the first tranche of report and then conclude the matters. And that's why we've asked the board to cooperate extensively with the investigation. Thank you.
Ndoliwa Mrangadzulu.
Thanks very much, Honorable Pila. Honorable Nilmay.
Thank you. It is the graveyard
Chair.
shift.
Oh, sorry.
I'm told that the acting chief of audit is Shonisani Makachava. So there is someone acting.
All right. Thanks very much. Honorable Nilmay.
No, thank you very much. And as we get to the end of the day, this is the graveyard shift. And we all starting to feel a little sleepy. We should be standing up and getting some exercise. Good afternoon, colleagues. Good afternoon to the Deputy Minister and the DG and your officials. Deputy Minister, I am of the view that the shareholder representative's role must be more focused. I agree with the chairperson when he mentioned that this morning. It should be structured and proactive. There should be a standard reporting template that enables the shareholder representative to report consistently to the executive authority and parliament, and to flag early warning signals before governance, financial or operational failures escalate. We've sat here and with other entities as well, and they all seem to have gone through the same challenges. I'm not going to mention the other boards and the other entities, but there seems to be a challenge in the early warning system, and there seems to be a delay in intervention. So from the ministry's point of view, Deputy Minister, how are you going to be able to, in future, to interact faster when those early warning signals arrive?
Thank you, Honourable Newman. Yes, you are correct. Part of our observation in ensuring coherence in the ecosystem and in the reporting has been to, one, engage with all the shareholder representatives, which we have, in the entities that are eligible for a shareholder representative, and infuse their work more strongly and more structuredly with the state-owned companies division in the branch, rather, in the department, and the public entity oversight. So that's point number one. Two is to indicate that the shareholder representatives must be able to interact directly with the minister and myself, and to raise matters in real time, and to provide reports. I mean, what we're not looking for is minutes. Don't come report minutes and apologies and what. That in the ordinary course of work we will get, but is to have a sharper focus on the substantive policy matters which are confronting entities, and we are now working on that kind of reporting. DG earlier on did explain around the report back to office structure which is there, and the template that is there. So this is one area where we are paying a lot of attention to, because we believe that it is important, and I think also it's also about building relations. It's important just between the ministry and those colleagues who are there, because, as I said, for lack of a better phrase, they're volunteering, because this does not come with additional remuneration, nor does any other benefit, and above and beyond, they don't have voting rights in the board ecosystem. but they must substantively be the eyes and ears of the shareholder. And lastly is to indicate, we have said to them, having received your board pack, you must traverse it so that you can get a mandate on the key areas, so that the views on the position of the shareholder can be placed to the meeting, and for the board to make a decision understanding where the ministry actually stands. So we are working on that, and I think we will be able to achieve the kind of coherence that you want.
Thank you. DM, I think one of the most important things that you can actually possibly assist with, and that is to work with the Department of Justice in looking at the tribunal or special court. I think for the country's sake, that is something that we need to deal with and needs to be dealt with urgently. You did say that you've met with the minister, and I really think that is like a very important aspect for the whole legal system that is jammed at the moment in the courts. So I think that is one other area that I'm going to be making some comments, and there will be some questions, but I want to support your interaction with the Department of Justice. The next area that I wanted to speak about is, you know, laws are made a year or two or three before. Now that we have seen both sides of the good and the bad of RAF, now that we have AI, DM, why can't we put ourselves in the claimant's shoes and walk that road? Go back to basics and actually put a program together on the computer, AI, to test the journey, that the legislation that we are going to put together now, or that we want to bring together, is actually going to be in the best interests of the claimant, and actually what it is that the purpose that the bill, that the RAPS is going to be. So that is one of the areas that I'd like to say. We have AI, we can add all the different components to it, the legislation, and really now from an actuarial point of view, we have all of that as now. We're in this kind of environment, you know, fourth industrial revolution, we've got, you know, AI. I think before we finalize is actually put oneself in the claimant's shoes and then determine how everything is going to take place. Are we going to have a panel of attorneys? Are we not going to have one? If we don't have that, how are we going to navigate that? Is it direct claimants? Do we have the capacity? The costs of the claimant. I think we've walked that road, and we've basically, ourselves as a committee, have walked the road of the claimant to actually see how that journey has been so difficult. And everybody, it seemed like, had good intentions to try and make a better situation, because you know, the old board came in, sorry, with the CEO. They saw that road and it was disastrous. We now have a new board, and sorry, and that board has laid an excellent foundation. And what one doesn't want to destroy is the foundation that has now been laid. How are you going to guarantee that the foundation that the interim board has started to put together is not going to be disrupted by a new board?
Right, thank you. No, Honourable New May. Yes, the work we are doing, of course, with the Department of Justice is to look at what short-term, long-term and medium-term interventions we can make. A special tribunal with the status of a high court would require a legislative process, and so that might take a while. Our energy right now is focusing on what can be done now and how it can be done, and that is why DG was making reference to mediation and arbitration driven by the courts. It's of absolute importance, and I think that we are at the tail end of really concluding the extensive consultations, and we just need to now engage with the judiciary. As I'm saying, the courts have got quite a number of issues with us, and I don't envisage an easy meeting with them. It's going to be very difficult, but at least we're traversing this journey with the Department of Justice. The Department of Justice has in fact roped in the Solicitor General, amongst others, to strengthen at a very high level the people involved in this work that we are doing. So that will receive our attention. I really want to agree with you, actuarial experiment from an AI perspective. I think it's a necessary intervention. We just need to ensure we've got the skill set, funds and resources to be able to do that, so we can traverse that one very quickly. And then lastly is that we remain committed, honourable members, and I want to assure you and the public that coming from the very difficult era where we are coming from, we have got every intention of a strengthened and maximized utilization of the foundations that have been laid in a very short space of time by the interim board. And for me, they have demonstrated what happens when you have men and women committed to just the job and nothing more and nothing less, to actually get things done. And I believe that we are setting the right tone and direction, and it is our commitment to ultimately appoint a board that is fit for purpose, and a board that will understand the intricacies and the difficulties we are in and be able to take the REF forward. Ultimately, all that we want is probably two things. One, the governance realities in the overall material aspects must be adhered to. And then secondly, REF must respond to its mandate. And I again want to say we must place an emphasis on the claimant with a particular and specific bias to the poor. For me, that will be mission accomplished, because the previously disadvantaged people of our country, if systems don't change, find themselves presently disadvantaged and excluded. We cannot drive the inequality gap by failed systems which are not responsive and not agile as and when they are called upon to do so. So that is where our focus is, and we are committed to a REF that works and a REF that is going to deliver. And that foundation that the board has laid and the corrective interventions they've made are important building blocks for the future.
Chair, I've got two very short ones. The other area that is of concern is the cyber attacks and the condition of ICT and state security. From a department's point of view, and DM, is there any way that one will look from a department's point of view that the ICT systems talk to each other? Because we're in that environment where you can open your desktop and be able to look at everything that's happening at the Road Accident Fund or any other entities that you have. But they were telling us that none of their systems talk to each other. The SAP system, they had a breach of 35 million, whereby payments between the 8th and the 12th of August 2024, there were interception of payments via abuse of privileged access to alter vendor bank accounts. and that is 35.6 million. So that is probably what they've just found, and that is from the AG's identified specific instances. So I would like to say from your department, and it seems as though because you look all over the world, look at departments, ICT and security is absolutely fundamental. And from your side, what do you envisage looking in the future going forward with regards to the security of, because look, if you think of the money that they deal with, it's huge amounts, you know, and they get a lot every month, you know, it's what's 4 billion or something. So that is a lot of money. So one really has to say focus on the security aspects of those monies that are coming in. So going forward, I'd like to say that needs to be one of your priorities. And then I have just one last closing comment.
Honourable Neil May, again, you are correct that we need to build up the capacity from a security point of view, including cyber security, given the sheer magnitude of the operations within REF. And this is not just the protection of the finances, but it's also the protection of personal information of the claimants that we are dealing with, whom for all intents and purposes lay themselves bare to us in terms of their health and privacy and so on. So we've got a bigger responsibility to be sensitive to that information. Well, some of it, of course, will require the assistance of Parliament, because, I mean, CETA is CETA. So I think maybe that's one observation to make. But lastly, I want to make the point that the IT capabilities of the department are receiving attention. DG can indicate that we are trying to build up IT capabilities to streamline and consolidate all that which requires online services and activities within our space. But Honourable Neil May, you and I will know better. Chaos is a conducive and enabling environment for corruption. And so these lapses in security and so on may not be accidental. And so it is important, therefore, that we move with speed as we are. And again, we have asked the board to look at it and lay a foundation. Also, of course, we are sensible to the fact that we must be measured in what we ask of the board. One, it's an interim board. It's not. It has not reached the threshold of 12 members. We appointed a smaller number to also emphasize that it's an interim board, so that they must also know that they too are a interim board. But I think what they will help us to do, the incoming board will have a stronger handover report of where issues are and what needs to be done. And of course, we will strategize moving forward on the apex priorities. Thank you very much.
And my closing shot. Chairperson, DM, you mentioned something very interesting. And I think this is something that we as Parliament and as responsible citizens need to look at. We are a country of drinkers. It seems as though it's entrenched in our culture. On a Saturday, on a Sunday, Friday night, Saturday, Sunday, you can go to the beachfront. I'm talking about where I live in the Eastern Cape. You can go to Ganubi. The booths are open and everybody's drinking. They leave their driving, speeding down the main road. You can phone the station commander. I do many times. Yes, he's getting to it. So I think we need to look at a campaign of zero tolerance, because to stop the road accident fatalities, it's between the taxi industry and our drinking and driving. They will speed, drinking and driving. And I think you speed when you've been drinking, or you're crawling. It's one of the two. I've looked and I'm not quite sure which one is worse. But if you think of how we keep fighting with the taxis, when we're driving, how our people are bumped, how our drivers, the taxi industry are the rule of the law. You know, they drive anywhere from a pavement to the side of a curb, you name it. They carry people in there every single day. And it seems to be the holy grail. I know my taxi operators in East London are going to wait for me when I get home. But, yeah. But what I'm saying is I think that really needs to, it's the elephant in the room as well, that we somehow don't want to really touch. I have seen your campaigns. I have seen since all the accidents, and I would like to say, you know, that is something that maybe we should continue, not just when we have these big accidents, but that we continue with regards to making sure that anybody who is carrying passengers must be compliant, and that really has to be something that, and they need to make sure, if you're a taxi operator, you go back for driving lessons. You have to, because the way taxis are driving is unacceptable, I think, to all citizens. Thank you, Chair.
Thank you very much, Honorable Nilme. You know, when you said you phoned the station commander, I was worried that you were going to say you also find them with their boot open drinking. That being Buffalo City, anything is possible. I must also say that the DG, I suspect that he can take anything, because earlier on he said that he wishes, since he's under oath, he wishes to tell the committee that he wasn't there. He was having a nice time with taxis and buses, and I thought, if somebody is able to have a better time with the taxi industry, then they can deal with anything. Yeah. So maybe you need to talk to Honorable Neil May, TG, and try and sort out things down there in Buffalo City. Honorable Beasley.
Chair, sorry.
Sorry.
I think one must want to build on what Honorable Neil May is saying. I'm sorry, Honorable Beasley. We must, Chair, concede to the fact that we have got a crisis in the country. Whilst we have been able to reduce fatalities year on year from 2024 to 2025 by about 6.4%, it is still 11,400 lives we lost on our roads throughout the year. And 80% of all accidents can be traced back to driver behavior on the roads and non-compliance with the rules, cell phone usage behind the steering wheel, and so on and so forth. And of course, the issue of alcohol is key, because we are generally a very entertainment-driven country, and a lot of our accidents are taking place between Friday and Sunday in the hours of 7 p.m. and 10 p.m. and in between 12 and 1 and in the early hours of the morning. I agree that we need to engage with the taxi industry continuously, as we are, to professionalize, particularly around conduct and driving on our roads. But Honorable Neil May, the other sad truth we need to confront is, without absolving the taxi industry, because by sheer proportion, one taxi industry has got more fatalities or casualties, is that taxis only account for 7% of fatalities. It's the individual car users who are, and at the same time, of course, we are not ignorant to the fact that the conduct of taxi drivers is a contributing factor to distractions on the road. So it is a very difficult space to navigate. But I think the point of departure, clarion call we need to actually make is that all of us must adhere to the rules of the road. It is of absolute critical importance. That is why we are working towards the zero limit alcohol in driving. We have also indicated that incrementally we'll be introducing advanced driver training as a requirement for scholar transport drivers. as part of the broader reforms that we are seeking to build in, and the work is well underway to review the entire ecosystem. I'm just happy that we've got an ally in yourself in this committee who was prepared to traverse this journey with us. Because, as I say, to resolve part of the road accident fund problems, we have to work hard on road safety. So, Chair, we want to lobby you if we can get more money for traffic law enforcement, 24/7 visible policing as we want to do. It will help us. Currently, it's only Western Cape and the National Traffic Police that provide 24/7 traffic law enforcement. If we can build up that capacity just to be visible and present on our roads, it will be important. So in the conversations you have around the budget, Chair, more money, please, for traffic law.
There's Mr. Moneybags,
It will help.
Honorable Beasley there. You're talking to the right person. So you can start the conversation now. Honorable Beasley, over to you.
There was a hashtag, Chair, to say pay back the money. Can I start one that says give us the money? Thanks, Chair.
Thank you.
Thank you, Chair. Greetings, DM and your team, and my colleagues and support staff. Yeah, it's been quite a long day, long week, a long 3 weeks. So I think, we've always tried to be, as Action SA, a constructive opposition party. We're not part of the GNU, and I want to compliment you and the Minister for taking a stand against the board. I did write a letter, and the first time I met the board, and I said, this is shambolic. They need to go. And you guys acted on it, and I must compliment you on doing that, because very few departments have actually done that. So I do compliment you on that. But my question is a bit of a deep question, a bit of reflection, because the last 5 years for the RAF has been disastrous. It has been led by a CEO that I would describe as a narcissist, a sociopath, and a psychopath altogether, and a board that is non-existent at the moment.
Point of order, Chair. Point of order, no. We cannot allow such. No, we can't. We can't have a character who is supposed to be a subject of this committee to be characterized in such a brutal manner. It can be. Otherwise, no official will ever come here. If we're going to character assassinate and call officials like that, and it's allowed, no.
Honorable Member, I'll consult the rules on this. The only thing I would, in the meantime, I'll come to you, Honorable Kupek. So I'll consult the rules on this, because off the top of my head, I'm not able to say whether the characterization is unparliamentary or not. What I would encourage the members, though, to do is that, given that we must deliberate on our report still, beginning next week, I would like to ask that we perhaps try and express ourselves fundamentally through the report that we write, or in our deliberations on consideration of evidence. I understand, Honorable Beasley, the frustration, and you've expressed it many times, but I think it also would be helpful if we are a lot more cautious with our words. But Honorable Member, I will consult the rules.
Yeah, Chair, for the sake of peace, I'll withdraw that comment, and I didn't mean to offend anybody who yeah. So that, but I do think.
Sorry, Honorable Beasley, my apologies. I'll stop the clock. Honorable Kubeka had put up his hand, so I don't know if you want to say something.
I wanted to echo Honorable Mendes' sentiments in that that was a bit harsh from Honorable Beasley, but he's withdrawn, so I think we're
okay, so we're all good. Okay, no, thanks very much, Honorable Members. Please proceed.
I do withdraw it. I do think I've just seen the pain on people's eyes, the drama that it's incurred, the inflection on it. So I do carry that quite heavily. And as a parliamentarian, I must be true to my to the people I'm representing. So let's just say he was unfitting. That's if that's an acceptable word. In my opinion, he was unfitting, and the board was non-existent. And how is it possible, and this is a reflection on Parliament and the department, that it actually allowed it to happen? And I'm going to read back a quote, and it's not to catch anybody, but this is a quote. I'll give you a clue who said this quote, because this is the headline. The RAF board is not fit for purpose and it must be dismissed, Scopa chair says. And that was in 2023. So nothing was, and it's not a critique of yourself because it's part of the ecosystem. You know, how was it allowed to happen for 3 years that after that quote was actually said, that there was a qualified audit, disclaimed audit report, adverse audit report, SIU investigation, the Auditor General made an investigation, yet nothing happened. And for me, that's a huge indictment on government and on Parliament itself. So just wonder, very briefly, how did it go wrong and how do we stop it actually going wrong again? Because I sit here in Scopa and you've got like Department of Defence, Denel, having a disclaimed qualified audit report, yet they're wanting more money. How can you give an organisation more money who has a disclaimed qualified audit report? So just from a governance perspective, how could things go so wrong from an oversight parliamentary point of view?
Thank you very much, Honourable Beasley. Well, I think, Chair, what I sought to do is to not migrate Scopa into the department and therefore the entities without the benefit of looking and assessing matters from the vantage point of the department. It would have been incorrect for me to do so. And I think secondly was to assume the responsibilities in a manner that would say, how do we fix this? And give it the benefit of doubt. Understanding, I think this is important, that it's a huge opportunity cost in terms of time and the public suffering that was there. But it would not have been prudent, in my view. History will judge, but when you assume a new responsibility, you want to locate its operations within the broader set of responsibilities. And I think sufficient benefit of doubt was given to the board. And that's why I said earlier on, sufficient pleading was done, nudging, cajoling, and so on, until it was just no longer possible to continue on that trajectory. And the past experience only confirmed, or was confirmed by what I found in the new, but I couldn't, in good faith, engage on a prejudicial point of view. On arrival, ngithi, Khan, it would not have been good governance.
No, I appreciate that, but I'm just talking about from Parliament overall, the Department of Transport, Parliament itself. So it's not a finger pointing at Scopa per se. It's something that's gone wrong to allow this to happen for 5 years. So it's not you as a Scopa chair or Scopa itself. It's the Department of Transport, Parliament. There's a committee on transport. Nothing happened in 5 years.
Well, I think it's part of the shared experience which we would have walked, and I think this committee built on that experience, and I think that's why we're here. It's incremental, and hence I keep making reference to some of the past activities. But what I do think, Honourable Beasley, is important here is just generally, I tend to hold Scopa, and this is not with any bias to my 10 years on this committee, Chair, but I hold it to a higher pedestal because of this. It's the one committee that must take a decision on the basis of the material facts. Portfolio committees consider all sorts of other things. But here, It's important. And that is why I support the inquiry, because my default position is to take it from an objective point of view, that's what it seeks to do. And lastly, is to say, if there's nothing wrong, then there's nothing to be fixed. Then we wouldn't be here. We are precisely here because we intend to fix. I mean, I'll take it a step further, Chair. Just on hindsight of everything, even entities with clean audits, so-called clean audits, as far as I see it, must still be subjected to a particular scope process. You know, so there's always transition and learning. It never stops. So I think there's serious lessons that we have learned, and part of the interventions we are doing are because we recognize the shortcomings of the past that have been there. My mother, who was a nurse, used to say prevention is better than cure. So we're trying to plug in preventative action steps for the future.
Thank you. So the one thing that seems hugely aligned, and I'm still new to Parliament and I'm still learning the processes, but the board and the executives used to wax lyrically how they met their performance targets of 84% to 90%. And the Auditor General said they missed some of the key targets which impacted on the lived experience. But how can performance targets be so misaligned to the actual reality, and how is that actually possible, and the actual role of the Department of Transport in that to make sure that the performance targets are more actually aligned to the lived reality of people on the floor? Because there's no ways logically that they can have a performance target of 90%, yet the lived reality for so many, including the staff. And the lady who I'm actually going to visit on Tuesdays, on Thursdays on Suicide Watch, because of what experience she's actually happened. So the lived reality is so bad by so many people, yet they've got a 84% target. So how can it be so misaligned? And as I say, I'm new to Parliament, so I'm still trying to learn the processes. Thank you.
Can I ask DG to... He's been in government longer than I have.
Thank you, Honorable DM. Look, the Honorable members, the setting of targets may not necessarily be misaligned, but would find a critical target is 1 of the 10. And then you achieve the 10. I mean 9 out of 10 is 90. And then the one that you might have left out is at the core. So it is always important to then lift that up, like the AG will always do. But that does not take away the fact that overall, on a numerical basis, the targets are 9 out of 10. So some of us have the school of thought that the fewer you have, and those that are critical to a core business, the better. Because then you will focus more on those ones and not put them together with, what do you call it, submissions on time and other related issues that are not necessarily core. So that is basically what happens to the majority. DM said earlier on, you are likely to find out even those that would get 100%. But if you dive deeper, you'll find out that the ratios are not agreeing when you do a proper financial analysis, because that is non-financial performance. If I say I'm going to buy 10 bicycles, and I buy 10 bicycles, I would have achieved 100%. But that is not talking to the lived experience. It does not talk to the accidents. It does not talk to road safety issues in my case. It does not talk to potholes that are all over the country. So I think that is and then that one then needs proactive analysis of the APP before it is approved. That it talks to the mandate. And it talks to, and that's why we are going to be busy with what we call accountability framework, because then roles will be clarified and people will then have to take responsibility so that you further segregate them in terms of their own importance. Thank you very much.
Yeah, DG, I want to just build on one point. Obviously, targets, for as far as I'm concerned, must be mandate anchored, core function anchored. So I always just think it's laughable when an entity says target 100% response to parliamentary questions. That's not a target. That's elementary part of the cause, right? It's not one of those things that shouldn't even be there, because it's not as if we've got an option to respond to parliamentary questions. And I'm happy to report that as DOT come end of 2025, we had no outstanding questions to Parliament, because it's elementary part of the cause. It's part of the things that you should be doing as part of your responsibilities. But I can just building on DG's comments and responses that targets must be mandate anchored, and then you'll be able to make a greater determination as to whether then you are doing what you are supposed to be doing.
Thanks. And just from the administration point of view, who sets the targets? Is it the department, or is it the portfolio committee on transport? Do they approve it? Who actually comes up with those targets?
Well, we derive targets from, I don't know how far back can I go, but in the start of an administration, you will have government priorities. In this case, in the 7th administration, are called MTDPs, and there are 3 of them. And then out of that, you draw out a strategic plan for the department, informed by that, but also informed by what the Minister of Defence discussed with the principals and the President, which forms part of the performance agreement. And then out of the 5-year strategic plan, you have the yearly targets. And then every year you do an APP, which tells you what you are going to do per year. Now, we take those for quality check by AG, if you have time, proactive probity on that. We also take them to DPME to see if there's alignment to the MTDP. But also Parliament. At the start of the administration, it might not be prudent, but what do you call, is it handover report? I think there's a term for it. In that, you'll get some of the issues that would have been raised in Parliament by stakeholders, and they form part of the BBR. And those, again, needs to be then be translated into those yearly targets. So everybody has got a role to do. I think maybe going forward, this proactive assessment, which is just a value add, needs to be strengthened to make sure that it has got power to strengthen, to see if what is in the yearly target responds to what the oversight bodies, the mandate of the department, performance agreement, MTDP, whether they are being addressed by those targets. That's the planning process. Thank you.
Thanks, Chair. And just the last point. So DM, I mean, it's an issue that, I've raised quite a few times. It's just the liabilities of REF. And my sense is, and I'm saying it respectfully, people have got their head in the sand, because we can increase the amount of claims being processed, we can include, but the reality of it, REF doesn't have the money to pay our claims. At the moment, there's 20 billion requests to be paid, not yet paid, and there's still 80 billion that settlement offers. So it's 100 billion. And I say liquid, real assets, we can talk about, liabilities, we can talk about liabilities, and then there's still another 400 billion. So the reality of it, REF doesn't have, if the boards became very efficient, REF became very efficient, people would still be waiting for their money, because REF doesn't have any money. And I've been trying to figure out how this is actually going to be solved, because the reality of it, the Minister of Finance is not going to give quantum amount of money to the RAF, because who would give an organization more money when it's got a disclaimed adverse audit report with the SIU all over it? You've got an interim board. So what are your thoughts around that? Because are we not lying to the people of South Africa saying, you know, we're improving RAF, things are going to get better, but the reality, people won't get paid money earlier because there is a huge liquidity cash and the RAF just doesn't have the money to pay out claims timeously. Thank you.
Chairperson, you would be aware that the board has taken a decision to withdraw from the Constitutional Court on its action, on the entity's action on the accounting standards. And therefore, accordingly, we are going to have to look at the books on the basis of what is correct as an accounting standard, and which is only then that we'll understand the magnitude of what we are dealing with. I would not want to, at this point, venture into that because there are consequences that we are going to realize because of that decision of reverting back to GRAP. And it does mean we are venturing into a moment of reckoning in terms of confronting very harsh realities of what our books will look like. But I rather we deal with that than an illusion of what's the extent of the situation. The liabilities are going to form a large part of the new reality of what we have to confront. And I'm pretty certain that the board is applying its mind to look at those future forward projections. We will also obviously have to engage with what this means, right? But liabilities notwithstanding, and this is not to say we must not focus on them, where we can pay and where we must pay, we must pay. I would not want a situation where we say because our liabilities are going to be more pronounced and then default into a lethargy. Let me put it that way. So my expectation is that the process which we are currently engaged in of dealing with the backlog and paying claimants, we must continue doing that. The second one is that we need to, as we already are, consider alternative funding models and revenue generating streams for the road accident fund above and beyond what we are collecting at the pumps. Thirdly is to tighten up on the internal controls so that where there's wastage and leakages, we close that. So it has to be a broader financial discipline that we employ within the road accident fund, and we need to revert back to core function. Avoid mission drift and all these other colorful things that I hear are happening at RAF, where there's a bus that goes around checking people like the pepper train that they have. That 20 million rands odd could cover a claimant or claimants, right? So we need to revert to core function, not these expeditions where we are trying to be a jack of all trades and the master of none. We need to go back to what we need to do. So this transition period is important because it takes us back to basics. And what it also does do is that where recoveries must be made by the SIU process and other processes, we must do that so that every cent we receive goes to co-function. I'm under no illusions, Honorable Beasley, that things will not be easy before they get better. But we rather go through that painful reality, confront it for what it is, and get out of it together, having at the very least been able to correct. And that's why, Chair, the annuities outlook is to sort of help us stagger things and slow down the pace. Lastly, I want to say that, and assure the public that we remain committed, particularly on this front, on a ref that is responsive, notwithstanding the difficulties. What I don't want, Honourable Beasley, is your concerns and outlook, notwithstanding about the liabilities, for that to be the defining feature. Yes, it's going to be a problem, but the flip side of that is the key question as to whether are we responding to that problem or not. And it is our commitment to respond to it. And I want to say that we will continue on the payments. And I think maybe, Chair, lastly is to say we also need to deal with the fraudulent claims because they are bleeding the system. We need to have a law enforcement agencies which are going to help us investigate. Like I've said before here, it is not lost on me what happened when my brother was assaulted by people, injured, and when I left the casualty ward, someone outside said to me, you should have said it's an accident, so that you could have claimed. So there's also the elements of corruption within the healthcare sector. What DG was saying, these people advertising, if you go to your classifieds right now, all sorts of ref lawyers are there. Let me help you with your claim, with your ref claims. The commercialization of the ref process has compromised its noble intentions about helping and assisting people who have been injured in accidents. It's become a money-making scheme, and it's detrimental to its core function. Thank you.
All right, thank you very much, Honorable Beasley. And DM, I do want to ask some questions that help us with recommendations, but I saw Honorable Maduna lifting up a finger saying he's got one question. Oh, I open a floodgate. Okay, that's fine. Honorable Maduna and Honorable Delmay.
No, thanks, Chair. I will make it one question. It's possible to make it one question, TM. No, TM, thanks. I think it helps for us, especially what I would have been asking around the department, because I believe it's important that we establish a process so that you don't one day end up yourselves making announcements that you don't understand, that have not been properly processed or that have been processed wrongly by the department. Because I mean, it would embarrass the principal. And I believe that the department officials know very well that usually it's not necessary for a from the executive authority or ministers to be professionals in a particular field for them to be ministers. So you expect officials to do their job in order for you to not mislead the public. So that's why it was important that we canvass that, we try to establish, so that as well it also helps for our report. But then lastly, on the current board, TM, I must say that I'm quite worried. I would have been happy if perhaps it would have happened that you would have had the short clip of the conversation that we would have had with them yesterday. I think I'm just gonna outline just about 4 or 5 issues that I believe that are very critical. One, to me, it was disappointing to learn yesterday that they don't know. They were learning yesterday that there are files that are still with the law firms of individuals that would have claimed to have. That would then mean the matters of those people have not been attended to. So that is just one of the things, that there are law firms that have not returned files of people at RAF. Two, it was the issue of the CEO. The issue of the CEO, the way in which they explain it, I appreciate that they tried to come up with a solution to it, but it brings the question, how did you identify the CEO? That is the question now that it brings, because the person was no longer part of the employee of RAF. How did they fetch the person? It then now brings question in the public, what was the process? Because I asked them a numerous number of times and they could not identify, they could not answer me what was the process, because it's not like Mr. Songelo has been a CEO before. So the question was, how did you identify him? It's fine, you fetch him, but stay on the street, he's no longer an employee of RAF. How did you identify him? Of which they could not answer. Secondly, when I spoke to them about I spoke to them about the issue of the current acting CEO. Chief Internal Auditor, I even tell them about the international practicing standards, of which do not allow him to audit a process in which he participated in its implementation, whether internal control, risk management, or governance process, for a cooling period of 12 months. My question was, after his acting instinct has lapsed, where will he work? Because he's supposed to audit the entire organization. And the auditing standards now internationally do not allow him to audit the process in which he was part of. That's one other issue that it got me worried. They gave an answer. I think the teacher would have been here, but I was not satisfied. Fourthly, I must say that they are in the process of appointing executives. I would have then directed them to 11C of RAF, of which I believe the chair, the chair of the ARC would have came to you yesterday that she apologizes. She read a wrong bullet, not the one I was sending her to. It clearly states that the recommendation of appointment of executives, similar to them, they do the process according to that act. They do the process of appointing a CEO. Then the minister must complete the process. Then the minister must approve whatever they would have recommended. Obviously, I believe they submit a number of names, not names in each in order. However, in terms of executives, because their performance, the CEO is responsible for. They are usually recommended by CEO to board for approval. Now, they themselves as board have started this process, but then I think in the conversation that we would have had with them, they said they will go back and stop the process and then consult legally to see how they go about that. So that's one other issue that I'm worried that your board would have engaged in. Lastly, there was an issue of them being involved in operational matters, such as signing letters of people that are being suspended. Now, the process, it opens it as if it's a board process, not a process of management. There are a number of issues, I think about 11 of decisions that your board would have made, which would take me to the question that I would have with you. I want to ask you, TM, in terms of what you would have, the scope that you would have given me, I appreciate the work that they would have done. But I want to put it into you that I do not believe that the board is adequately configured. I see that there are some of, especially within the board, there are some of them who are actually experts in and given that RAF is in crisis and are equal to the task. But I want to put it to you that not all of them are going to assist RAF in moving forward. In light of everything else that I would have highlighted above, it's just that I did not want to, because it would deal with our time. So I believe that there is some from their side entrenchment to operational matters. Their explanation that they would have gave is that they have a lot of people that they would have suspended. They have a lot of people who are acting, of which it leaves them with no option. But it's an issue that I want to raise with you, because now in a couple of months you might have an issue of irregular expenditures, irregular that, irregular dismissals, irregular that, because of the over-involvement of board. So I wanted to check that. Are you, when you look at their expertise, believe that they will be able to take it forward until such time that you or do you believe that this is the board that you would have, the best board that you would have in this period of transition that you would have appointed? Lastly, I wanted to I think I wanted to ask that, and given that especially the chairperson, the chairperson was the chief procurement officer, but I believe me and you, because I believe you would have done a background check. The chairperson, when he left at as a chief procurement officer, he would have had allegations that were hanging over his head, that there were dubious payments that were made to his home loan, of which he would have resigned shortly after Hawks would have started investigation into that. So, in line with that, I just wanted to ask that, Chair, because it's important that we raise these things. And then in line with that, I wanted to check the capabilities of the board, and do you believe that ethically the board will be able to be the buffer between now and when you appoint the board? I think that was that. Thank you very much. Oh, and lastly, Ngela, when you do DM, get to a point whereby you appoint a board. Siyacela humbly, please do consider young people as well. We believe that they are the ones who understand today's world, the world of AI, which is what RAF needs. The ideas, especially the technology and the fast-moving world of today. So I do not believe that a board currently, like for instance, the interim board with an average age of 60 of above 60 is going to assist RAF going forward. Thank you.
Thank you very much. Let me start off at the last comment. It is elementary for the minister and myself that all boards have to be representative in the material definition of representation, and we will endeavor to do that, to couple representation with skills, knowledge, and expertise. As a young person self, because I'm still under 40, Chair, is to highlight one point. The only way to get experience is through experience and exposure, and so that remains part of our own outlook. Under the circumstances of what we were saddled with, we had to move with a particular speed, and I keep emphasizing this is an interim board. We are engaged in the appointment process in its material aspects, and the necessary due diligence will be applied for everyone. So I certainly do agree with you that the board must be representative, and young people will be represented on the board. There's certainly no problem about that. Do I believe that the board that we have now is fit for purpose? Yes, I do. I think under the circumstances, these are individuals we threw into the deep end at a time when also the CEO was on suspension, and subsequently his term expired. We had dissolved a board. We had an SIU investigation. You had a negative audit outcome that you are dealing with. And the whole barrage of issues, and we took them, threw them in there, and I think what they've done over the past 6 months is good work, and I think that we owe them a huge grade of gratitude just for agreeing, for starters, and for immersing themselves into this work as they should, and the very difficult decisions they've had to take, or taking the bull by the horns, whereas we've had to suspend, well, they've had to suspend executives. That's not an easy decision. I don't think there's any board that would just waltz in and start suspending executives. It had to have been duly considered. I think, as I've said, let's allow the disciplinary processes to run their course. That is absolutely important. And for the SIU to complete its investigation so that we know where we are. So, yes, I've got full confidence in the board, but my confidence and support is conditional for any board. Do the right things. Act in the interests of the entity and be engageable on key policy matters. Because policy remains the purview of the ministry and the department, and the entities implement. There must be no confusion, whether it's today or any other day. That's what we expect the board to do, and co-function as per the legislation. So I think under the circumstances, that's important. Your first point is about discovering or finding out about funds. Well, what I can tell you is that under the circumstances at REF, you're going to keep on finding out quite a lot. Inda you find out that's because you know, Honorable Matuna, that in one meeting here, the chairperson of the board presented a particular set of series of events about her own participation in a meeting, right? And the suspended CFO seated there contradicted her. I can't imagine coming to this meeting and then I say, no, I went to that meeting and I referred some questions to the DG, and then the DG comes and says, he never referred any questions, contradicting me about my own participation. The point I'm trying to make is that before we get REF right, we are still going to have to navigate fully the test of information integrity, because it's lapsing. It had lapsed rather because there's a selective giving out of information. Will this get me in trouble? How can I protect myself? There's a trust deficit which exists within REF. And the board has been systematically trying to navigate, weed through, peel the onion as layers as it is. And at some point, if you peel an onion, you know you're going to cry. And that's why we're here. Because the more we dig, the more we find out things. Some of the issues, Chair, are with the law enforcement agencies. So the whole point is that it should not shock you if you find out. I mean, I'm not sure how far the committee is with its assessment of the law firms that were paid monies, because there was, I think, understating of funds that the entity had provided to yourselves, if I recall correctly, on what had been paid. So there's still a lot wrong, even at the governance level and at information integrity, but we will get it right. The last 2 points. I again concede to the fact that the manner in which no matter the explanation that the board provided in how they appointed the acting CEO, we did not agree with it when the full set of information was presented. And I think it's a learning experience for the board as well in how they process information. And I think they were able to respond positively to the issues we raised with them, and that matter was rectified. And I think we are quite confident that an engageable board and a responsive board is what we need. And lastly is, well, I think we will engage with the board around what we do to the chief audit once his tenure ends of acting. For now, I think he is also a great enabler for the board, just from where he was seated, to be able to point out, because Honorable Maduna, here's the reality. Some of the information was set on, and some people were not in a position to speak, because if they spoke, they would bear the brutal brunt of the powers that were. And so as part of cleaning the ecosystem is to hear the unheard voices and to understand their observations and their issues around what's happening at REF. And I think that is something we need to embrace, I don't know, freedom has finally come at REF. Thank you.
All right, thank you very much. Honourable Nilme, you've got one question.
Yes. No, Chair. DM, with the reconfiguration of RAF, what other countries have a road accident fund, and has there been any benchmarking, or will you be doing any benchmarking with regards to what other countries have our kind of system or something similar? Or are we the only country in the world that has a road accident fund?
Chair, just one thing. Honourable Matuna, you say that we are not, the board is not adequately configured. I think we need to tread also whilst we wanting to sort things out, to err on the side of caution. This is an interim board. And so we must also limit the extent to which we constitute a board. And when you start venturing to full constitution of a board, you run the risk of entrenching them. It must be understood that they are interim, and we will be having to go through the substantive processes. Can I just ask DG to speak about benchmarking, but of course we try and operate REF against international standards.
Thank you, Honorable DM. We did, in the initial round of the RAPS bill process, we did quite a substantial benchmarking exercise. The no-fault system is based on the Australian model, and then there are Scandinavian countries that are utilizing the road accident as a benefit scheme. But most countries are still utilizing what you'd call motor vehicle insurance. So people are like the USA, most states in the USA, people are still have to keep proof of insurance for you to drive a vehicle. If you don't have, it's a big problem. So we did that, and then we went into Eastern Africa, Kenya. We benchmark around that. That was the most, I would say, acceptable middle road that we could come to. But like I say, I think the discussion on RAPS will have to start very soon, Deputy Minister. There seems to be an appetite to engage on it, and we're more than happy to discuss and listen. Thank you very much.
All right, thank you very much. DM, we right to the end. So I'm going to put some propositions to you, which I think with the Secretariat we might want to put before the committee in the area of recommendations. So I will put some propositions to you for your comment, and then that will help us work out some of your thoughts and how we form our own thoughts relative to how you respond to them. But before we do that, I just want to clear something, which is the term of this board ends on the 7th. So what you are saying in plain language is that on or before the 7th, the minister will announce a new board, because that's the only way we can express it simply. Because the 7th, I think, is on Saturday, if I'm correct. So either on between Friday and Monday, because you also said that there can't not be a board. So I just want to be clear. And will that be a full board, or you continue along the lines of interim?
Oh, thanks, Chair. I thought you were still. Chair, we have to have a board, and the only construct which we have, which has gone through the checks and balances of, at the very least, cabinet, is the current board, interim board, and therefore the intention is to extend the interim board until such time that we have concluded the process of appointing a board, and we intend to move with speed on the appointment of the board. As I've said, the Chair, I think it's important to just clarify. We advertised at a difficult time.
No, you explained, dear. I'm satisfied with your answer.
And lastly, is to say, post the interview process we still have to do what do you call it? Gazetting. So it's we still have to gazette for public comment, even those that we nominate. So this particular board does tend to have other additions above and beyond what may be ordinarily in the process, and we're still going to interview as part of our new construct as the ministry. So we will extend this current board, Chair.
All right. Okay. No, thanks, Deputy Minister. So, let me put some propositions to you based on at least my own observations, but also with the assistance of the committee secretariat as we reviewed the hearings and some of the evidence, and some of this we're likely to then place before the committee for consideration, and that is, having had regard for the governance environment at the Road Accident Fund, and so that I don't speak in parables, I will make some examples, some concrete examples, so that you understand where I'm coming from. Having had regard for the governance environment, it may be necessary for you and the minister to commission a policy and governance review at the Road Accident Fund in order to ensure that the policies as they have evolved and exist comply not only with the RAF Act, but with the principles of corporate governance, with the PFMA, etc., etc. So let me give you some examples so that you know where I am coming from. I may have mentioned earlier that the delegations of authority at the Road Accident Fund appear to be all over the place, and we canvass this with the board. The board delegates authority to the chief executive. The chief executive then wears the cloak of the board and delegates that same authority to someone else. Now, the authority does not belong to the chief executive, it belongs to the board. He or she does not then replace the board on delegating to other people, and that is in respect of policies. It's also in respect of policy formulation, internal policy, but it's also in respect of the level signing, financial transaction signing authority levels, right? So that is one example. The second example has to do with what has evolved at the Road Accident Fund, which is, if officials are not acting, executives, if officials are acting, the board does not need to approve, which is how the former board ended up with a chief financial officer they could not remember. And that chief financial officer is the one who instigated the accounting policy change, but they couldn't remember her. You end up with those things. So I won't go through the full list, but it would appear to me that the board reporting back to the minister in terms of a comprehensive review of what these policies, and therefore what steps they propose are taken, might be necessary. So let me just ask you to comment on that. If you have no comment, it's fine. It doesn't mean you disagree. I just need to put the proposition to you.
Chair, I would want to adopt my Hambagahle approach if those are going to be the recommendations or the propositions of the committee, we would want to look at them in their material entirety in the report that you are going to provide. Suffice it to say, the question maybe we might need to ask ourselves is, was it a policy and governance failure in terms of how it's crafted, or was it because the individuals given the responsibility, either one, were derelict in the exercise of their duties, or two, they abused their powers? So we have to look at all of that. And my sense, Chair, is that the board was derelict in the exercise of its duties, in that it abdicated its centrality as the accounting authority and allowed a situation where for a very long time were one. Angazi, Honorable Madlala, what's the saying? That's the phrasing. He will explain. They were one.
The DM says something and then he says, Madlala, explain.
So, just that saying.
We're waiting for Mazala to explain.
So they were one, right? There was cohesion between the board and the CEO, and I want to believe a particular cohort at the executives. Something somewhere broke the camel's back. And I think, Chair, that is what I am grappling with. How did, by the time that happened, the cohesion was gone? Because that will help us understand what happened. Because we enjoyed a situation where the oneness of the board and executives was judge, jury, prosecutor, and master. Now, what we need to therefore do is delineate responsibility, function, and authority back to their respective parts or constructs within REF, and instill the checks and balances necessary for the entity to function like any other entity should. That's the issue. So that's what I'm saying. We'll of course await, but I want to await your recommendation. But I wanted to give a perspective as to say part of, and probably in large part, the major problem we had was relations and patronage in whatever form or construct it may have been dispersed.
All right, DM, the second area that I'll just, in fact, let me just complete all the observations. I think that will get us through quite quickly, and then you can just make a sort of a comprehensive comment. The second area is that the information that we have received, and I think the board expressed themselves sufficiently yesterday, is that the management of litigation is deeply problematic, and it leads to ballooning legal costs. And those are matters that pertain to not just a panel of attorneys. We received similar testimony with regards to the panel of medical experts. And that is the lack of clarity around that ecosystem has meant that cases get postponed, RAF is not ready, not enough people to handle cases, medical reports expire, etc., etc., etc. That's an area that I think we will have an ask of you and the board to make sure that that mess is sorted out, because it is costing the road accident fund money, and that there needs to be a plan that is shared with us in response as to how they're going to deal with this, linking it specifically to how the cases of the number of cases ezidingayo that are not under somebody's care, active care, is that is the one area. The second area has to do with the costs aligning to plaintiff attorneys, which is what the whole country talks about. And that shouting at the problem does not solve it. It is also an area where I would like the ministry to consider that it may be necessary to do something either about regulations or legislation now while a comprehensive solution is being worked on. Because as long as, and I'm mindful of the intervention of the judge president, the problem with it is that it's how one division has elected to deal with the matter. It's not a national solution, and we've got a national problem. We need to arrive at a way of dealing with the litigation and litigation costs that is consistent throughout the system. So that would be the second area. The third area has to do with assessments of the board. We've canvassed this about shareholder representatives, but I think the templating of the reporting on a regular basis to assist the ministry to be comfortable that the board is performing at the right level or not just against targets, but in general. That is the one area. The other area, which the Auditor General has raised, that the APPs as approved do not address some of the core legislative requirements. So in other words, the bar is too low, and therefore it always shows a high performance. But you know very well, DM, that both when you were in this seat and when you became deputy minister with delegated authority for the RAF, you've had a headache for years, even though the entity is performing. Right? So that the process of approving APPs is really strident and takes account of the specific issues that have been raised with Parliament in the 6th Parliament and this Parliament itself. So that is the other area. I do want to say that it would appear that the management situation at the Road Accident Fund right now is that there is no succession pipeline to speak of. It's gone, which is a problem the board is sitting with. And that presents significant risks in terms of management's collective ability to adequately look after the circa 50 billion they get allocated from the fiscals. And yesterday I used the following metrics. What you want is collective experience at executive level to be a significant number of years for a 50 billion rand entity. I think we can agree that the people currently in post, if together they've got 20 years experience at executive level, it's a lot. And some of that benchmarking needs to be done in order to make sure that you've got sufficient bench strength. Because what you don't want to do, and again, I want to be careful not to undermine people, that what you have is people who would have been senior managers now are now executives. Because there are no more people. So putting someone with a law degree or who's a CA, does not mean that they're able to operate at a certain level of risk, responsibility, and executive management, and people leadership, and this kind of thing, and strategy, such that you and minister can sleep at night. So there is that problem, and I want to say that we will put it in the report specifically to say that the Road Accident Fund should have a certain level of experience at executive level, which would mean that it might be necessary for the Road Accident Fund to look outside for certain roles because there's just not sufficient experience internally. It's just a thought that I'm leaving with you. And then the last point that I want to make has to do with to Honorable Maduna's point, and I'll say why we arrived at this. The boards previously did not appear to have, I see what you're saying about people being at one and so on, but there were instances where we were really talking, and you could tell the innocence of the board members. In other words, they simply also cannot conceive of certain reports in their heads, that sometimes you ask management to draw out certain information for you so that you can make a decision. Because they just lightweight, to be frank with you, they're lightweight. And I am saying this with the utmost respect, because the people try very hard, but the outcome is still the same. It's the kind of headache that you and Parliament are dealing with. And so I just want to say, we will apply ourselves as the committee to how we can best assist to set out some criteria that might be helpful to the department and to all ministers henceforth in terms of making sure that we get the right people. I do want to say one of the things we'll have to debate in the committee fiercely, to Honorable Maduna's point, I don't believe a 50 billion rand entity is where you give people a chance to learn. We will have to debate that very seriously. There are opportunities in the public sector where you can do that. A 50 billion rand entity affecting circa 3.5 million people at any point in time, we perhaps need to be careful. Does that mean within our public sector system, in the transport environment and so on, we don't create opportunities for pipelining younger people into boards? But it may mean that you still need a more experienced person looking after a particular portfolio on that board. And we accept that the person is there to learn. What we cannot afford is people who have serious responsibilities, but where they work full-time, it's unimaginable that they would be given those responsibilities, because we then harm ourselves. And so we have to, as a committee, just argue about where the point of balance is on these matters, because I believe that we do experiment to the detriment of the South African people. In the Road Accident Fund Board, the one that was disestablished, there was a lawyer. You would not say there was a lawyer, but there was an advocate. Do we want to destroy? Because in the event that this committee decides that some of the board members, if not all, were delinquent, let's just say, as an example, that person's career is destroyed. We don't want to be doing that, because it might not mean that person is rogue, but they were just in the wrong size of environment and they shouldn't have been there. So what I'm trying to say is, and similar with the former Chief Financial Officer, Acting Chief Financial Officer, Ms. Mabusela, I was at pains to explain to her how her lack of knowledge about the role of the ASB will harm her career as a CA. She continued and she buried herself because she does not have the experience, and she was put in the position of a Chief Financial Officer. So I'm just sharing this generally for all of us and for your consideration, DM. The last point I want to make also has to do with how we manage the financial sustainability of the Road Accident Fund. I think we might, at some point, DM, maybe after the report, have to have a discussion about the discussion we are postponing by talking about the RAPS bill. Having read that RABs. I don't know what's coming out in the next one, but I think if the principles are generally the same, the changes that are going to make a difference sooner must be to the RAF Act. Because simply throwing a line in the sand and saying from then on we're doing things this way, the fiscal hole remains. And I think, DM, you will be chased away by Treasury almost every time you go there to ask for 32 billion. They're going to say no, right? Which means we are not able to assist you, notwithstanding Honorable Beasley's willingness to do so in the Finance Committee and so on. So let me just allow you, at your discretion to comment on all of this. But these are matters that I certainly, together with the Secretariat, we will place before the committee just to deliberate on so that we know how to formulate our report. Thank you.
Thank you, Chair. May I ask DG to start off, and I'll make 1 or 2 comments. Thanks.
Thank you very much, Chair. Thank you very much, Honorable Chair, and thank to the honorable members for the discussions. Chair, I didn't watch TikTok clips, but I watched the entire proceedings yesterday, and the manner you repeating almost verbatim these issues, like you converse them with the boards, I'm quite sure that they are going to find their way into the report, TM. And it is because they are the real facts and are probably summing up the observations, even for us that they were not part of some of the earlier deliberations, are now converted, Chair. I started early on to try and craft what will be the takeaways for the department, and the majority of the cases, I think, we converge. Thank you very much, Chairperson. Just quick issues, not to say no, but just to amplify and agree with the Chair. Chair, there is this thing they called, in the legal people, delegatus non potest. I think your first point touches on that. The original owner of the powers is the only one that can delegate. So delegated authority can be delegated further. It's as simple as that. I want to stop there on that one. Chair, I think where the department, more especially at officials level, would want to really dive in and assist is on the relevance, correctness, and verifiability of the targets, just to make them more crisp. The department itself was being qualified on this information until we got it right, and I'm sure we can share the experiences with the fund. Chair, thank you very much. I thought I would say a word or two on the issue of putting inexperienced people into the deep for fear of exposing my own age. Nothing beats experience, Chairperson. And then the other thing, Chair, whether we call it RAPS or something else, I think there are elements, like we said, that are good, as per proposed in the RAPS bill, and there are elements that you say are urgent, now, which were incorporated in what was termed the amendment bill. So as much as we're looking at short, medium, and long term, there are those things that we need to do in the short term, and if they really talk to legislation, I think we need to have that opening to deal with the issues. I had thought that the third thing about this whole thing, and I'm wrapping up, Chair, the third thing about this is that we lost the work that was done on dealing with this erosion of the claimant and not the victim as core to what RAF is all about. And then we brought back into the back door some of these people that we say have been defrauding RAF. And I think maybe that is an element that we need as a department to monitor very carefully, because it is, you need to juxtapose that with what the chair is saying. The removal of the panel, whether it's of attorneys and or medical practitioners, brought us into this mess. But also I think just to reverse that decision and go back to the original decision will not assist, because we needed to deal with the people who were dealing with the fund in a very unscrupulous manner. Yeah. Continue.
He's delegating upwards.
I'm a young lawyer.
No, Chair, I think at the outset one would want to express appreciation to yourselves for the stewardship of this process. I'm sure you still have a lot of work to traverse as you look at RAF. And of course we have work to do as well. I think, however, Chair, respectfully, I think the committee must be in a position to allow the legislative reform process to run its ordinary course until it gets to Parliament. Because I think on reflection to the comment I made earlier on about coming back to present on reps, it may be irregular for the parliamentary process and maybe circumventing PCOT on the work that it should do. We will bring a bill to Parliament, Chair, and we will subject it to the parliamentary process. And we intend, in fact, on Friday, I'm meeting with the roads branch, the department, to see where we are with the very last stages of the nitty-gritties of that bill and the certifications we need so that it can. So we are at the tail end of it. Whichever comes first, whether that bill coming to Parliament or Cabinet Parliament or your recommendations, in one way or the other, like a belt, it will eventually connect as we wear it. So we will sort that out. Chair, I agree with you that the assessment of boards is critical to make sure that they continue to perform. But what I must place, and it's certainly not canvassing to remain in this position, but the reality of the matter is the only space where you can get hired or fired at will is in the executive. The president can exercise his prerogative, which is fine. But we can't just waltz in and fire a board. You have to go through a particular process. And the process, in one way or the other, requires you to engage. So there's certain constraints you need to engage in to make sure that you are correct in the decisions that you take. And the same applies here, because you are dealing with professionals who, amongst others, you say have got career considerations, reputational risk mitigations, and so on. But ultimately, a decision has to be taken. So I think we also need to clarify for ourselves the ease at which these things can be done. That's part one. The second point, Chair, is government is, for all intents and purposes, run by officials. who've got permanent jobs, and people who are either on a contract or on a prerogative appointment who can leave at any time have to oversee those people. Minister Chris is Minister 13 at Transport, I'm DM number 6. You do not know what will happen tomorrow. So the ecosystem is not balanced to ensure stability at decision-making level. And those are part of the problems of why we are here. Because I can tell you now, Chair, there was great hope that the minister and I would be gone. Right? These ones, bayasangana nje, bayaqhuma, excitable. Tina will be here. They found us here. They will leave us here. So as you speak about board's assessment, I'm trying to advance a point that you are absolutely correct, because if we have a standard benchmark, regardless of whoever comes in and out, they've got that background upon which to be able to hold accountable. And this, of course, then goes to your senior managers and so on. My second to last point, Chair. Whilst the point may be valid that in 50 billion rands entity is not a place to land, I think what we must best endeavor to do is to locate the necessary knowledge, skills, and expertise for people to perform there. And I can tell you that even with 10 years of, or 15 years or 20 years of experience, you would still come into REF and have to learn. We need to be, seated here, how our budget, DG, 98% of it goes to entities, and we left with, and provinces, and we left with 2%, almost 80 billion rands. The question could very well be, Uti, and your DM, I must, Chair, respectfully ask us to tread with caution about how we couch exposure for young people. Because if you're speaking about the pipeline, we need to be able to establish it early. What we rather should be saying, how do we expose and create and shadow at the very least? But that exposure is important. When I got to this parliament at 24, I was much younger than Matuna, but still more handsome than him. And
I thought Matuna matriculated during the election.
So I got here, Chair, and I remember very well my first day here. One member, whom I'm happy to report is no longer in Parliament, said to me in the Defence Committee, when Mr. Mwango, who chairs the Land Committee now, was introducing me, they're very happy. Hey, you've got a young fellow here, is 24, yada, yada. And this member said, this is precisely why we need national service in this country. Parliament is not for kids. We must, Chairperson, at all costs fight ageism. But what we must not compromise on is accountability on anyone and everyone we deploy, anyone that we send into a board. Because, Chair, I can say here and say people with experience and expertise have caused the messes we are in that we are trying to resolve. Let us work towards building up the young people of this country so that they can take ownership and responsibility for the developmental agenda that we have. And if they mess up their REF, equal measure of consequence management must apply. If I failed in my duties as the deputy minister, the president must fire me and not keep me there because I'm young, because it doesn't build me. Consequence management, including but not limited to firing people, is growth, because it teaches you. So I'm left with a teeny-weeny bit of consternation about the comment that you made. But I will insist on skill, I will insist on expertise, but insist on growth as well, Chair. I mean, abantu abadala abanye have caused big problems in this country, and other young people have fixed it. So it depends where we are. My last point, Chair, to the committee and to the South African public. Chair, we appreciate the efforts of the committee. I know that sometimes we complain because you send a lot of letters, but I believe it's for the greater good. I want to assure South Africans that we are equal to the task and to the challenges which beset the Road Accident Fund. It is not going to be an easy journey because we are trying to turn around an entity that for quite some time found itself as the playground and fiefdoms of ulterior motives. On the surface of it, a picture was presented that says, we are sorting out the problems. Only we can sort out the problems. But on closer engagement and interaction, the rot runs deep. The rot runs deep. All is not well at REF. But the efforts we are making are, for all intents and purposes, intended just to fix things for the better. And we are asking for partnership to help us to draw our attention to the fault lines and the challenges, and we are prepared to listen. And where decisive decisions, Chairperson, are required, best believe Minister Chrissy and I will not shy away from making and taking those decisions, because we only have one intention: restoring the claimant as the point of centrality to the Road Accident Fund, so that we can be able to achieve the mandate. We look forward to your report, Chairperson, and the recommendations that you will pass through the House, and we will engage and interact with them, and where they are feasible, viable, and within the policy outlook that we have determined, we will make it a point that we incorporate them into the next chapter and phase of the Road Accident Fund. I conclude by saying this, Chair, because a perception again in public has been created. None of the decisions we have taken have been personal, nor are they decisions on the basis of grudges. To Honorable Beasley's point that he made, we sufficiently gave everybody the benefit of doubt to wake up to the realities of the challenges. It did not happen, and we acted. So we meant no personal malice. We did not go on a witch hunt. If anything, the decisions we have taken were invited by the incumbent Chairperson, and we will continue on that trajectory. We have sleepless nights. My son has told me I've got a gray hair somewhere here, and I want to believe it's thanks to REF. Thank you, Chairperson. Take care, and God bless.
Thanks very much, TM. I also understand the top of my head is thinning, which wasn't the case when we started this process. Thanks very much, DG. Thank you very much, and your colleagues. Honorable members, so what I propose we do is that over the next couple of days, the Honorable Maduna, you're not going to hear me now. So over the next couple of days, with the Secretariat team, we will finalize the reports frame and elevate the key issues on which we need to consider what was placed before us during this process, both in documentary form, but also in the form of testimony, and that when we convene on Tuesday, we approve, we debate, we make inputs, and it will be sent ahead of time to the members. We make inputs so that as the team then writes the report, it knows that it is staying in parameters and on issues agreed to by the committee. We are going to drive ourselves quite hard, Shaman. They're all hiding under the, but we want to conclude this process as quickly as possible. So the idea is that towards the end of the month, we are able to consider a full draft report for the committee, so that we can then share the relevant parts thereof with the affected parties, because we also undertook to give them an opportunity to comment and make inputs, if you recall, and also to assist with recommendations they believe may be helpful. So what I'm trying to say is we want to conclude this process as fast as possible. We will, though, because of the nature of the work, start considering other matters that have been held in abeyance. So we are going to have to multitask in that time. But I just want to say, framework issues and so on will be sent to the committee members before Tuesday. Then we debate, at least as we go, the committee knows what type of issues the team is putting together in the report, if that's helpful. We'll also then have updates around the issues that are with the speaker, because we've also in the background been in touch with the Secretary to Parliament and the Speaker's office for the guidance that we agreed is needed from the Speaker's office. But honourable members, honourable Skosan, sorry.
Yeah, Chair, I did not get you well. Are you saying the report will be sent to us before Tuesday, or you are saying we are meeting on Tuesday to consider it?
No. So what the team, what we'll do with the team, will develop a frame for the report. So you will get what the shape of it will look like and what the sections in it are, so that if there is an issue we are omitting, members may say, but we must also include this issue. Alternately, for members to say, we don't think this issue is so material in the report, we can leave it out. So that when the team now writes the report, and they've given a lot of thought already to what kind of that work should be. So we're not starting everything from scratch, but we don't want the team to work on a draft report that the members might decide when they get the draft that there are big chunks missing. So that's the objective. So I don't expect it would be a very long discussion on Tuesday. And that is that frame that will get sent ahead of Tuesday to members. I hope that assists.
Yeah, is it possible that we can meet visually on Tuesday?
Oh yes, no. Open to that, Honourable Skosan. As long as, for me, as long as the members as long as the members get an opportunity to discuss the framework and the issues, it's fine. Perfect. Yes. Honourable Atkinson?
I see that Wednesday being put aside for that as well. Are we only going to be doing it on Tuesday, and that's it, basically?
No, remember that what we had said at the beginning of this meeting, so the reason it was Wednesday is because we had, just in case, that the members might want to see the minister. In which case we would then see the minister and do this on Tuesday. But I do think that we've canvassed the issues sufficiently with the DM. We don't need to have the minister on Tuesday, and therefore we can discuss a frame on Wednesday. So on Tuesday, so that on Wednesday, I think SONA is on Wednesday.
Thursday.
Oh, is it on Thursday?
Yeah.
Okay, we'll work out what we do, but Tuesday is virtual.
Fantastic.
Okay. All right. Thank you very much, Honor. Thank you very much, DM and colleagues from Transport.